Oh, it is cool. Ah,
Hello.
All right, good afternoon, everyone.
Good afternoon, Your Honor.
Hello.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
Good afternoon.
Good afternoon.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
Good afternoon, Mr. Bartels. All right, if we're ready to start, we will get started. All right, we're going to begin our Fulton County Expedited Accusations calendar. And this is a calendar for cases that have recently been accused, and these individuals have been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused these cases of the offenses brought against them, and the cases have been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we are going to and able to address several matters, including bond, possible arraignment, and possible plea offer if one has been made by the state at this juncture. I want to provide you with that SAP reset date, Ms. Bridgewater, which
Yes,
is?
it's going to be January the 29th.
Okay, January the 29th. All right. And so that's the SAP reset date. I also want to advise everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube, so govern yourselves accordingly. I also want to remind the defendants on this calendar that you have certain constitutional rights. The first being that you have right to counsel. Most of you should know who your attorneys are at this point and have spoken to them prior to this hearing. Also, I want to remind you that you have a right to remain silent. Remember that anything that you state about the facts, the circumstances, or the occurrences of your case can and will be used against you. The state is here and they're listening. So again, follow the lead of your attorney. All right, deputies, who do we have first?
We're gonna go position number 2, Ms. Brancho. This is the interpreter case.
Okay. And hi, Ms. Chansey. How are you this afternoon?
I'm doing well, thank you, Your Honor.
All right. This is position 2, which is 26 CR 000361B. Hilda Brancho Parara.
Muy bien, esta es la posición 2, que es el número de caso 26CR000361B, la señor o señorita Hilda Brancho Parra.
All right. And Ms. Chansey, let me swear you in, please.
Yes, ma'am.
Raise your right hand for me. Do you affirm that you will interpret from Spanish to English, English to Spanish, the proceedings before the court today in the proper manner without any embellishments?
I do, Your Honor.
Okay.
Yes.
All right. Thank you.
You're welcome.
All right. And this defendant is charged with 1 count of stalking and a 2nd count of harassing communications. Retrial?
Y los cargos que tiene esta acusada es de acecho y también por emitir comunicaciones de hostigamiento.
Good morning, Judge. In
Good
regards to
afternoon.
defendant, no prior arrest history. If you choose to release her, pretrial recommends UJR jail, nothing further.
All right.
La acusada no tiene ningún arresto anterior. Si usted prefiere, puede ofrecer la libertad a través de los servicios previos al juicio, a quien recomienda la liberación judicial sin fianza.
All right, State.
Fiscalía.
Good afternoon, Judge.
Good afternoon.
Hope all is well.
Yeah, thank you.
This is an event that happened on January 15th of this year. Officers were dispatched to 219 Hembry Park Terrace in reference to possible stalking charge. They did make contact with the victim in this case, who is Leonor Castro.
One moment, please. Este es un evento que ocurrió el 15 de enero de este año. Los oficiales fueron despachados al 219 Henry Park Terrace con respecto a un posible acto de hostigamiento, el cargo. Ellos se contactaron con Leonor Castro. Thank you, sir.
Yes, Judge, I'm just going to summarize the factual basis and essentially the victim in this case did hire this defendant.
Voy a sumarizar el fundamento de hecho, pero esencialmente la víctima de este caso contrató a esta acusada.
And without getting in too deep of the facts, the victim who was later divorcing her husband, this defendant then began a relationship with the husband.
Y sin ir muy lejos con los hechos, la víctima estaba divorciándose con su esposo, eh, o sea, de esta acusada, comenzó a tener una relación con el marido de ella.
What the state believed the facts will show is that since that time, the defendant has been surveilling the home of the victim, sending text messages that were very intimidating to the victim.
Lo que la fiscalía cree que son los hechos que serán demostrados es que la acusada ha estado custodiando, vigilando la residencia de ellos. La víctima ha estado enviando mensajes escritos y o sea, mensajes de intimidación hacia la víctima.
To the point that the victim did contact law enforcement to make them aware of such incidences, and it was several of them.
Lo que en ese punto la víctima contactó a las fuerzas del orden para avisarles sobre estos incidentes y que fueron varios.
And although the state is aware that there is no criminal history, this case still gives us cause for pause and concern given the nature of the offenses.
Y aunque este caso no es un caso penal, sí, perdón, sin antecedentes penales, este caso nos da una fuerte causa o sea, y preocupación debido a la naturaleza del delito.
As such, the state is recommending a bond in the amount of $5,000, $2,500 on each charge, one being the stalking and the other being the harassing communications.
Entonces, la fiscalía recomienda una sentencia con fianza de $5,000, $2,500 por cada cargo de acecho y hostigamiento.
The state is recommending that the defendant undergoes a mental health evaluation and treatment if necessary.
Y también la fiscalía recomienda que la acusada se someta a una evaluación de estado mental y tratamiento si es necesario.
That the defendant stay completely away from the address that I gave, which was 219 Hembry Park Trail in Roswell, Georgia.
Y también que se emita una orden de prohibición de acercamiento a la dirección que acabo de dar, el 219 Henry Park Trail en Roswell, Georgia.
And have no further contact with the victim or alleged, in this case, Miss Leonor Castro.
Y no tener contacto alguno con la víctima alegada, en este caso Leonor Castro.
And no alcohol, drugs, or illegal weapons while out on bond. Thank you,
Y,
Judge.
y que se prohíbe el uso de drogas, alcohol y armas. Gracias, su señoría.
All right. Mr. Bartels?
Señor
Yes,
Bartel.
thank you, Your Honor. I have spoken with Ms. Brancho with the assistance of the phone interpreter.
Yo he hablado con la señora Brancho con la asistencia de un intérprete por teléfono.
I'm advised that she is no longer employed by Ms. Castro or has any other type of relationship with Ms. Castro.
Y le he recomendado que ella no está, y avisado que no está más empleada por la señora Castro y ni que tenga ningún tipo de relación con la señora Castro.
We would submit that, well, based on what's in the warrant, I think the contents of these text messages are ambiguous. It could be argued a number of different ways.
También sostenemos que basado en la orden de arresto, el contenido de los mensajes que enviados son ambiguos y podrían ser debatidos en un número de formas diferentes.
And however, because we are here, Ms. Brancho certainly is clear and understands that Ms. Castro doesn't want any contact with her, and she does not want any contact with Ms. Castro either.
Y debido a que estamos aquí, ella entiende, la señora Brancho entiende que la señora Castro no quiere tener ningún tipo de contacto con ella, ni ella quiere tenerlo con la señora Castro.
And regarding Bond, as the court has heard, it appears that she has no history at all.
Y debido a que no tiene antecedentes penales para considerar la fianza,
I am advised that she does not live at this address. I'm told that Ms. Brancho lives in Suwannee.
se me ha informado que la acusada no vive en esta residencia. Ella vive en Suwannee.
And it looks like Ms. Castro lives in Roswell.
Parece que la señora Castro vive en Roswell.
And I am advised that Ms. Brancho has been in Georgia over a year.
Y se me dijo que la señora Brancho vive en Georgia desde hace un año
And she is currently employed at City Light Electric Company.
y que está empleada en la compañía City Light Electric Company.
And given all of that, we would ask that she be allowed to sign her own bond and would certainly not have a problem with a no further contact and stay away.
Y por eso solicitamos que ella pueda firmar su propia fianza y no tenemos problema con la orden de no tener ningún contacto de ningún tipo.
And nothing further for now, Your Honor.
Nada más por ahora, su señoría.
Judge, I would ask that we sound for the victim, and that is the victim in this case, who is Miss Leonor Castro.
Señora Leonor Castro, si está presente en la plataforma de Zoom, avísenos, prenda su micrófono y su cámara, por favor, en este momento, ahora.
All right. Not hearing the victim, we'll move forward with the
Al no escuchar la presencia de la víctima, continuamos.
all right. State, are you recommending or are you against the signature bond, or would you like for pretrial to monitor?
La fiscalía solicita la firma, la fianza bajo firma y con la oficina de servicios anteriores al juicio que monitoree a esta acusada.
Thank you, Judge. The state would be fine with pretrial monitoring at level 3, and specifically if Your Honor is inclined to have that mental health evaluation is done.
Sí, la fiscalía está de acuerdo que los servicios previos al juicio monitoreen a la acusada en un nivel 3, dado que su señoría tiene la inclinación de que se haga esa evaluación psicológica.
Mr. Bartels, did you have any indication of any inmate issues when you interviewed the defendant?
Señor Bartel, ¿usted tuvo alguna indicación de algún problema en el momento que entrevistó a la acusada?
I did not, Your Honor. I'm not sure what the basis of that request is. I did not get any indication that Ms. Brancho had any difficulty understanding what was going on or what her options were.
And Your Honor,
No estoy seguro de por qué se puso ese requisito. No vi ninguna indicación que me dijera que la señora Broncho tiene alguna dificultad en entender lo que está sucediendo y cuáles son sus opciones.
Your Honor, I would just add that the basis is the nature of the unwarranted and creepy surveillance, as well as the messages that had been sent to this particular victim that were intimidating and threatening in nature.
Su señoría, yo quisiera agregar que la base es la naturaleza de los cargos por su indeseable y horrible custodia o vigilancia, al igual que los mensajes que ella envió a esta víctima en particular, que fueron intimidantes y amenazantes en su naturaleza.
I will not order an MH eval at this time. I'm going to order the $5,000 signature bond, and I will order that signature bond through the pretrial services with a
Ah,
level 3.
Sorry. Yo no voy a ordenar una evaluación de salud mental en este momento, pero sí ordeno una fianza de $5,000 bajo firma y la ordeno para que se realice a través de los servicios previos al juicio en el nivel 3.
All right, and that's 2,500 on each of the charges. I'm going to also order a stay away from the 219 Hembry Park Trail.
Yo ordeno también, o sea, son $2,500 por cada cargo y también emito una orden de prohibición de acercamiento al 219 Henry Park Trail.
No further contact with the victim, Leonora Castro.
No tener ningún contacto de ningún tipo con Leonor Castro, la víctima.
And no drugs, alcohol, weapons, or guns while on bond.
Y queda prohibido el uso de drogas, alcohol y armas mientras esté libre bajo fianza.
All right, anything else, counsel?
¿Algo
Uh,
más?
Nothing further. Thank you, Your Honor.
All right.
Nada
Nothing
más.
from the state.
Gracias.
Thank you, Judge. Appreciate it.
Nada de la fiscalía, gracias.
All right. Do you want to sound? Do we have any more cases for you, Ms. Chansey?
I'm not sure. I will sound.
Yeah. Position number 9, Mr. Gonzalez.
Oh,
Okay.
thank you.
Right. I believe that's a conflict case.
And I see Attorney McLeod.
Good afternoon, Your Honor.
Good afternoon. All right, this is 26 CR 0000366A. David Gonzalez, charged with 1 count of theft by shoplifting.
Este es entonces el caso 326CR000366A, el señor David González, con un cargo de robo de tienda.
Pre-trial.
8 cycles across 3 states.
Existen 8 ciclos de procesos a través de 3 estados.
3 holds, all for theft out of Dallas, Roswell, and North Augusta, with 4 holds in Greenville.
También 3 detenciones, todas por robo, desde Dallas, Roswell, en Augusta del Norte y 4 de Greenville.
On probation out of Henry for theft by shoplifting felony 2 counts, theft by shoplifting misdemeanor 6 counts, 12-125 for 5 years.
Después, libertad probatoria desde el condado de Henry por robo de tienda y un delito menor, 6 cargos o sea, 12 en 5 años.
Another probation out of Henry for theft by shoplifting, sentenced in 25 for 5 years.
Otra libertad probatoria del condado de Henry por robo de tienda con sentencia en 2025 por 5 años.
Open case Cherokee, theft by shoplifting from 12/3/25. Nothing further.
Por llevar un envase de bebida de alcohol abierta desde Cherokee a robo de tienda de 12 del marzo, perdón, 3 de diciembre del 2025 y eso es todo.
All right, State.
Yes, Your Honor. This is from April of 2025. Occurred at the Rack Room Shoes. The defendant in this particular case is accused of having taken several pair of shoes from that store.
Sí, su señoría, este es un caso que ocurrió en abril del 2025 en el negocio Rack Room Shoes y la acusada tomó en este particular caso varios pares de zapatos de la tienda.
And Your Honor, I do know that there's been some time in between the incident and today. However, it's just the warrant. He's not caught until he's caught.
Su señoría, yo entiendo que ha pasado un tiempo entre medio del incidente y hoy, sin embargo, solo, o sea, la orden de arresto eh, no se llama, no se utiliza hasta que se atrapa.
The state will, however, note the significant criminal history involving theft by shoplifting.
La fiscalía, sin embargo, notará que hay una historia muy relevante, una historia penal, antecedentes penales que involucran el robo de tienda.
And as you have heard from pretrial, which includes an open case as well as probation for the same type of offense.
Y también escuchó desde los servicios previos al juicio que incluye un envase de bebida alcohólica abierto por el mismo tipo de delito.
The state is recommending a good bond in the amount of $5,000.
La fiscalía recomienda una fianza en el monto de $5,000.
We're asking that he be required to undergo a cognitive behavioral health therapy.
Y también recomendamos que se someta a una terapia de salud cognitiva de comportamiento.
That will be through AACS,
Y eso va a ser a través de AACS,
which will focus on aversion and anti-theft for habitual violators.
que se enfoca en la aversión y contra el robo que se le ofrece a los acusados habituales.
That he stay away from the incident location, which is
Y también que se maneja, o sea, que se prohíba acercamiento al lugar del incidente, que es
7671 North Point Parkway in Alpharetta, Georgia.
7671 North Point Parkway in Alpharetta, Georgia.
That he has no alcohol, drugs, or weapons while out on bond.
Y que se prohíbe el uso de drogas, alcohol y armas mientras esté libre bajo fianza.
Thank you, Judge.
Gracias, su señoría.
All right, Attorney McLeod.
Yes, Your Honor. My client advises me that he has been locked up in Henry County for more than 50 days.
Su señoría, mi cliente me ha contado que él ha estado encerrado en el condado de Henry por más de 50 días.
Because of that, he is unemployed.
Debido a eso, él está desempleado. Lo acusaron por agresión con agravantes.
I'm not sure who said
No,
I don't know.
I
I
think
can.
that may have been a radio of one of the deputies, possibly, or somebody in the courtroom.
Let me apologize. That was me listening to a phone call from,
Okay.
so
I interpret what I hear.
Yeah,
an inmate called to a
anything.
victim. I'm sorry.
That's okay. Scratch that. All right, keep
Yes.
going.
So based on the fact that he's unemployed, of course, he's not in a position to pay or to pay anything significant for a good bond. So I'm not going to ask for signature bond because I know that the court is unlikely to grant that, given that there is some history. But I would ask for as low as possible good bond.
Entonces, basado en que él está desempleado y por supuesto él no está en la posición de pagar una fianza, eh, yo no voy a pedir una fianza bajo firma, ya que no creo que la jueza esté inclinada a otorgarla debido a los antecedentes penales, pero sí solicito la fianza en un monto más bajo posible, una fianza que se pueda pagar.
Yes, Your Honor. So a bond, say in the amount of $1,000 good bond, I think would be appropriate under the circumstances.
Y creo que bajo estas circunstancias, una fianza de $1,000 es lo que solicitamos.
Okay. I will order the $5,000 good bond or surety bond. Given that history and all the holds and things of that nature, I'm going to leave it at the 5,000. I'm going to ask him to stay away from Rack Room Shoes there at North Point Mall. I was getting ready to say stay away from all Rack Room Shoes in Fulton County, but I don't know that that's his store of choice, so I will just leave it to that location for now.
Voy a ordenar una fianza bajo garantía o judicial de $5,000 y dado a los antecedentes y también a todas las otras detenciones y cosas de esa naturaleza. Voy a dejar la fianza en $5,000 y también ordeno que no haya acercamiento en el negocio Rack Room Shoes. Lo iba a hacer para todos los negocios en el condado de Fulton, pero no sé si es el negocio de su elección o no, así que lo voy a dejar la prohibición solamente a ese local.
Okay. And I think also the state mentioned this AACS program. What is that?
Yes, Your Honor. The cognitive behavioral health evaluation really addresses addictive personalities for people that are compulsory thieves, kleptomania, things of that nature. Think that would be very beneficial. And AACS is a vendor that we utilize specifically for that program.
Creo
Will
que
he have
también
to
la
pay for this?
fiscalía recomendó ACS. ¿Qué es eso? Bueno, es un tratamiento que se basa en personas con intentos de robo compulsivo, cleptomanía, cosas de esa naturaleza. Y creo que sería muy beneficial para este acusado porque para que pueda utilizar todo eso que ofrece el programa.
Is this
Yes,
something he would
yes,
have to pay for, Mr. Rhodes?
yes, it is
I
something
would
that
strongly object to it. He has no money.
and yes, he would have to pay for it, or if he could find one that is comparable, the state would accept that if the court would.
Si se tiene que pagar, yo objeto, pero bueno, él podría también encontrar un programa que sea financieramente cómodo o accesible para eso.
Your Honor, I would strongly object to the course that the state is asking for. Bond is not supposed to be punitive. Bond is to ensure that someone will show up for their trial or for any other court proceedings. I have already stated on the record that my client has been locked up for quite some time. Oh, let me pause.
Oh, one moment, thank you. Su señoría, yo fuertemente objeto a este curso que la Fiscalía está solicitando, porque la fianza no está supuesta a ser un castigo, la fianza es para asegurar que alguien asista al juicio o cualquier proceso judicial. Yo ya he dicho que mi cliente ha estado encerrado por un largo tiempo. Thank you, ma'am.
Judge, I would just add that although that is true, the court can consider the defendant's multiple offenses of theft by shoplifting and make sure to ensure that that is addressed during bond.
Su señoría, yo quiero agregar que aunque es cierto, la señora jueza puede considerar al acusado, o sea, los delitos múltiples que ha cometido con referencia al robo y asegurarse que su señoría se dirija a esto, que trate esta condición.
Your Honor, I would say that if the state wants people to do these courses should be free to them. It's not about punishing someone. This is a bond. And that, under the circumstances, he's not getting a signature bond or anything. I don't think his bond should have any other conditions other than basic conditions such as no drugs, alcohol, or weapons.
Su señoría, yo quisiera decir que si la fiscalía desea que la gente tome estos cursos deberían ofrecerse de manera gratis. Entonces, porque no se trata de castigar a alguien. Esto es una fianza y bajo esas circunstancias él no está obteniendo una fianza bajo firma, perdón, o nada de eso. Y tampoco creo que esto debe ser otra condición de fianza, aparte de las condiciones básicas que se otorgan.
Judge, if I may just finally say that I believe that the defense counsel grossly undermines the public safety in this all. And in the alternative, if the court would be comfortable having him on an ankle monitor, which we often ask that they would have to pay for themselves as well, to ensure that he's not a public safety risk in continuing this line of conduct.
Bueno, si me permite, su señoría, por favor, yo finalmente quisiera decir que creo que la abogada de la defensa ampliamente no considera la seguridad pública y esto es una alternativa. Sí, por supuesto, lo acepta su señoría o tenerlo a él con un monitor de tobillo, que a veces también se pide, que el acusado tiene que pagarlo. El riesgo de la seguridad pública y continuar este tipo de conducta y comportamiento es lo que estas cosas intentan tratar.
Your Honor, there is no reason why the state would even need to consider ankle monitor in this case. He is not he's not a danger to the public. This is beginning to get into the realm of the absurd. And I have heard other Superior Court judges mention that they are not comfortable with all these conditions being slammed onto people as bond conditions, which get to the point that people are defaulting all over the place. There are bond conditions for them to pay this, pay that. These are misdemeanors we're dealing with. These
One
are
moment, please.
felonies.
Su señoría, no hay razón para que se recomiende un monitor de tobillo. Esto no es seguridad y él no está siendo un peligro para el público. Esto empieza a caer en lo absurdo. Y como sabe, he escuchado a jueces del Tribunal Superior que mencionan que no están cómodos con todo este tipo de condiciones que se le tiran a la gente como condiciones de fianza. Lo que es el punto de que la gente está incumpliendo en todos lados. Esta fianza o condición de fianza, para ellos tienen que pagarla. Estos son delitos menores con los que estamos tratando y no son delitos mayores.
Well, I understand the concerns on both sides, and I am certainly concerned with his history of theft and having the holds and being on probation. And I would love to order all of those. I prefer they be at sentencing. And again, this is for bond. Although, did I hear well, the probation violation, so maybe he doesn't show up in court.
One moment, please. Thank
Your
you. Entiendo las preocupaciones de ambos lados, pero con los antecedentes prefiero que, o sea, escuché que el incumplimiento de probatoria y entonces puede ser que haya una posibilidad también en que él no asista al tribunal.
Honor, I did not hear them say a probation violation. They said he was on probation.
Yo no escuché decir incumplimiento de probatoria, solo que estaba bajo libertad probatoria.
All right, I will just order then the $5,000 good bond. I'm going to order again that he stay away from the Rack Room Shoes there on North Point Parkway. I'm going to order no drugs, alcohol, weapons, or guns while on bond. And
Bueno, ordenaré entonces $5,000 de fianza. También ordeno una prohibición de acercamiento al negocio de Room Shoes que está en North Point Parkway, y también no se prohíbe el uso de drogas, alcohol y armas mientras esté libre bajo fianza.
okay, I think that is it. Anything else, counsel?
Creo que eso es
Nothing
todo.
further for the defense, Your Honor.
Nada
All
más
right.
de la defensa.
And nothing
Thank you.
for the state judge. Thank you.
Nothing else, thank you. Nada más, thank you. Gracias.
All right, thank you.
We can go to ACD, Steve.
All right. Do you have any other cases there that need an interpreter?
No, not here in courtroom 2.
Okay.
All
Let's see
right.
what we have in ACDC.
Petition number 14, Ms. Mitchell.
Do you have anyone there that needs an interpreter?
No, Your Honor.
Okay.
All right. Thank you, Your Honor. Have a great weekend.
You too. Thank you.
And Your Honor, before we get started on Ms. Mitchell, I do believe that there has been a consent bond, so I can,
Okay.
Yes, that is correct.
as it relates to, whenever you're ready, Your Honor.
Okay. This is position
14.
14. I'm sorry, I was on the wrong
And Your
number.
Honor, I am in receipt of that consent bond.
Great. This is 26 CR 000-372J, Shakita Mitchell. And what are the terms of the consent bond?
Yes, Your Honor. $4,000 sign-on bond through pretrial services level 1. The breakdown is $2,000 on each charge: the simple battery, family violence, and the criminal trespass. The damage to property at 2,000 each, sign on bond through pretrial services level 1, that Ms. Mitchell undergoes 5 anger awareness classes while on pretrial services. No further violent contact with her brother, the victim, Jarquez Kelly. And we ask that while on bond, she replace certain items that's listed in the bond order, which is television and video game that was broken and damaged. No alcohol, drugs, or illegal weapons while on bond.
All right. PD Bronstein, is that your understanding?
It is, and I spoke with Ms. Mitchell about it, and she agreed to the terms.
All right. I will sign that order shortly.
Thank you.
All right. Thank you.
Good afternoon, Judge. Could we take one out of order if that's possible, Miss Ellis?
Okay. Let's see. Where is she at ACDC or Fulton County?
Amita Ellis. I don't know where she's located.
Here, come on. Sorry, Your Honor, what was the last bond? What was the amount?
4,000 SOV pretrial level 1, 2,000 on each.
Got you.
Make that like that road floor. Oh, are you in a car? I'm on a Zoom. Mr. Patterson? Yes, I'm on a Zoom.
All right. Is this Mr. Patterson's client?
This is Miss Ellis.
Okay.
Position number 6.
This is 26 CR 0000378F. Almita Ellis, charged with 1 count of battery family violence, 1 count of cruelty to children. Pretrial.
Judge, in regards to Ms. Ellis, no prior arrest history. If you choose to release her, we recommend UJR, but if you're going to do it through pretrial, we recommend level 1, nothing further.
Thank you.
Good afternoon, Your Honor.
Good afternoon.
On January 16th of this year, Atlanta Police Department Officer Janice McGuire responded to 4119 Butternut Place in Atlanta, Georgia. The victim, Mr. Owen, reported that Ms. Ellis visited his residence with their daughter. After arriving late and missing a passport appointment, an argument began over parenting styles and evening plans. Mr. Owen asked Ms. Ellis to leave, and as they were exiting the home, the defendant slammed the door and began striking the victim when he tried to escort her out of the house. Both fell on the steps, and the defendant continued hitting the victim, causing multiple facial scratches and bleeding. The incident occurred in front of Mr. Owen's 4-year-old son. Mr. Owen's wife attempted to intervene. Your Honor, we did speak with the victim. He wants contact, and he did inform the state that the victim lives out of state. She lives in Jackson, Tennessee. Although she doesn't have any other criminal history, the state is asking for a surety bond since she does live out of state. So $1,000 surety, $500 for the battery, and $500 for the cruelty to children in the 3rd degree. No further violent contact with Mr. Owen, no drugs, alcohol, or weapons while on bond. And if we can please sound for the victim in case he's here and wishes to be heard.
All right. Is there Mr. Owen on the Zoom? Mr. Owen?
Yes, it's Owens. They got me blacked out. I don't know why.
Hold on a second. Can't talk to you till I can see you.
Hello, Your Honor.
Oh, hi. All right, Mr. Owens. Do you wish to make a brief statement to the court?
Yes, ma'am. Some of the details.
Hold on a second. Hold on a second. This is not your trial. This is a bond hearing, so I don't want to go over the details in general if they don't relate to some of the bond issues that I'm willing to discuss with you today. Raise your right hand first. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. I'm going to ask you 2 questions. First question, are you in fear of Miss Ellis?
No.
All right, do you want to have any further contact with Miss Ellis?
No.
Okay. You all have a child together?
Yes, ma'am.
All right, and the child is how old?
11.
11. Okay. All right. I don't have any other questions. Counsel, do you all have any questions?
No,
of this
Judge.
witness? Okay. State.
Your Honor, based on what Mr. Owens just stated, the city would like to ask for no further contact and a stay away from the incident location.
Okay. All right. All right, Mr. Owens, you can mute yourself, please, and continue listening to the proceedings. All right. Attorney Patterson, you may go.
Yes, Your Honor. Miss Ellis, she, as I previously said, she lives in Jackson, Tennessee. She's a program manager, single mother with the 1 child. We asked the court to give her a signature bond and certainly to allow her to go back home to Tennessee. We believe, Your Honor, she has no criminal history. She's a Delta Sigma Theta. She's an active officer of the Mother Liberty CME Church. She's the national chairperson for Founders Day of the CME Church. She formerly worked for the National Office of the Christian Methodist Episcopal Church. She is also a mentor to students, volunteers through Jack and Jill. She's an active PTA board person. She's an active parent at her daughter's school. She has no priors. We believe, Your Honor, that a unsecured bond completely with no violent contact, even though the victim said he wants no contact, they do have a child. So it's no question they have to have some contact. We just believe that it should not be any violent contact.
Okay. Since she has no history, seems to have stable employment and things of that nature. I do have some concerns because she's in Tennessee. Does the child, this 11-year-old, lives with her in Tennessee, correct?
That I'm not sure, Judge.
Oh, the father, he's stating yes. Okay. And Mr. Owens, do you have regular visitation? Are you all meeting somewhere in between, or she's coming back to Georgia to bring the child? How's that been working?
No, Your Honor. It's either she comes down here or I go up there. We have no agreement through the courts, no child support, no nothing.
Okay. All right. Go ahead quickly.
I just wanted to say, I didn't say, I don't say I don't want to have contact with my daughter. I just don't want to, I really don't want to have contact with her mother at this time.
Okay. Well, since your children are minors, right? Your daughter, there's a mention.
My son is 3 and he's by another woman here in Atlanta.
Oh,
my daughter is
her.
yes, but he was here. He was here
And
last
witnessed,
night.
right?
Yes.
And so the 11-year-old is still a minor, the child that you have with the defendant.
Yes, correct.
And so I guess if you all are going to continue visitation, I would put some obviously conditions on that to make sure it goes safe for
Your Honor.
everyone involved.
Your Honor, may I speak, please?
No, I don't think you should speak at this time, man. We're trying to get you out of jail on good conditions.
Okay. All right. So what I would like to do, since she has no history, and because of her involvements in that community, hopefully that will be a one and done situation and we won't have any other incidents to occur. I would order a $2,000 signature bond through pretrial services because of those charges. And that would be a level 2. I'm going to put her at a level 2 just because she's out of state, although it was recommended for level 1. And that'll be $1,500 on the battery, $500 on the cruelty, for a total of $2,000. I'm going to order that if there is visitation allowed with the minor child, that it be precipitated or facilitated by a third party, so that you all will not have to have contact. There are companies out there that do it, but there's also, if you have a friend that the two of you are a relative that the two of you can agree upon, that will be the go-between for the visitation, then let that be the case for now, until we can get through the case.
I can do that, Judge.
Okay, good. No drugs, alcohol, weapons, or guns while on bond. And since Miss Ellis is going through pretrial services, I want to order two anger awareness or anger awareness courses. They're free through pretrial services. I don't know, pretrial, are they virtual or in person?
I'm not sure.
You don't know if you have a virtual component. Check with them, Attorney Patterson. If not, then she can take two that are in Tennessee.
Okay.
And let's see, is there a requirement? Oh, for level 2, is there a requirement that they report in person? I need to find that out. If not, she will have to be a call-in.
I believe it is. Let me make sure. Let me open it back up.
Okay. Your camera's not on pretrial. Thank you.
Level 2 is, wait a minute. History checks per month, phone, virtual, monthly face-to-face.
Right, and we won't put that on her for level 2, but level 1 is called in virtual.
Yes,
Okay.
that's what the difference is.
Let us put her back to level 1. And then her attorney will find out whether she can take those two courses virtually with you all here in Atlanta. If not, she can find two courses in Tennessee where she is to take to kind of deal with those situations. And I guess that's all for now. Anything else?
Not at all. Your Honor, her family needs her social security number. Can she relate her tell us her social security number, Miss Ellis?
No.
I didn't.
Unfortunately, now let's see. You can chat to.
And since the judge gave her an unsecured bond, the bonding company we wouldn't need that anyway at this point. I just thought about that.
No.
No,
Yeah.
thank you so
Okay.
much.
Just want to make sure because this is being recorded.
Absolutely. No, that's fine. And that's all
Okay.
we have, Judge.
Okay, great. Thank you.
Thank you.
All right.
We can go back to ACDC.
Okay.
Position number 17, Ms. Preston.
All right. This is 26 CR 0000367D. Naomi Preston, charged with 1 count of simple battery and a 2nd count of battery family violence. Pretrial.
No prior arrest history. If you choose to release her, pretrial recommends UJR jail. Nothing further.
All right.
Yes, Your Honor. This incident is from January 15th of this year. Officer Leo Arnold was dispatched to 2873 Barnett Court Northwest in Atlanta, Georgia. He spoke with Ms. Joseph, who stated that her and the defendant, Ms. Preston, have been dating for 7 years and lived together. The altercation started because the defendant saw a text message that the victim received from a friend. She then pushed the victim and tried to snatch her phone away from her. Through the back and forth scuffle for the phone, Ms. Joseph received a scratch on her hand. The state's recommendation is a signature bond. No further violent contact with Ms. Joseph, no drugs, alcohol, or weapons while on bond.
And what was that recommendation? Repeat that for me.
Oh, yes, Your Honor. A signature bond, no further violent contact with Ms. Joseph, no drugs, alcohol, or weapons while on bond.
And what's the amount?
We can do $3,000 signature bond, $2,000 for the battery family violence, $1,000 for the simple battery family violence.
Okay.
And that was no violent contact?
Yes, no violent contact.
We'd ask that the court accept the state's recommendation.
All right, so that's a $3,000 signature bond. And because the simple battery family violence is restricted, is it not?
I'm sorry, Your Honor?
I think the simple battery family violence, is that a restricted charge that I have to go through pretrial?
I'm not
Yes, Your
sure.
Honor, that is correct.
That is correct, right? So it won't be through the jail, it'll be through pretrial services, and she'll be at a level 1. And so, Ms. Bridgewater, that's 2,000 on the battery family violence, 1,000 on the simple battery, and no further violent contact with the victim. No drugs, alcohol, weapons, or guns while on bond. And I didn't hear anything about a stay away, no?
No, Your Honor, the state is not recommending that.
All right. All right, anything else? PD Bronstein?
No, Your Honor.
All right, thank you.
Oh,
Oh.
I'm sorry, before you do go to the next case, I just wanted to let the court know I still need to speak to 2 people. I've been sending chats and haven't heard back from the jail yet on when I can do that.
All right, courtroom 2.
Yeah, I hate to use the word rounding them up, but we're getting them as we speak.
Okay, thank you.
Once
Thank
we
you.
have it here, we'll give you a call.
Okay.
Next we'll go with position number 3, Mr. Brown.
Okay. This is 26 CR 0000362G. Preston Brown, charged with 1 count of battery family violence, 2 counts of cruelty to children in the 3rd degree. Retrial.
Mr. Preston, only prior arrest is driving while license suspended to 8/25. If you choose to release him through pretrial, if you choose to release him, pretrial recommends UJR jail.
All right.
Yes, Your Honor, as it relates to Mr. Brown, I believe the state does concur with that history. So we are recommending and I did send to Ms. McLeod a consent bond. We're recommending a 5,000. I'm sorry, is it 5,000?
I did not receive one. Remember, I sent you a message to say who my clients were. I didn't receive any for either of those 3.
Okay. We're recommending a $5,000 signature bond through pretrial services level 1. The breakdown is as follows: 3,000 on the battery family violence and 1,000 on each one of the cruelty to children in the 2nd degree, for a total of 5,000. We are recommending that Mr. Cameron has no further contact with the victim, Miss Alexis Cameron. In this case, there was, in fact, a jail call where Mr. Brown indicated that he would like a one-time escort to get his clothes from that residence. The state does not object to the one-time escort for him to go get clothes from that residence, and that he stay away from that incident location. We're asking that, and that incident location is 3804 Martin Luther King Jr. Drive. We are asking that he, because this happened in front of the children, Your Honor, it does gives us significant cause for pause. The 2 children involved were minor children. So we are asking that he undergoes 24-week of family violent intervention program. Your Honor, I do understand Ms. McLeod's concern. However, there are judges that are the opposite. They do feel that the 24-week FFIP is appropriate at the bond stage, especially when children are impacted by these events. Your Honor, in the alternative, if not the 24-week FFIP, we'd be asking for the at least 5 anger awareness classes, as well as a parenting course for Mr. Brown. Do believe that I see an Alexis on. I don't know if it's Alexis Cameron. the two of them have been conversing via the jail phone calls. Thank you, Judge.
Okay, thank you. All right.
Your Honor, I am okay with the signature bond for my client. I am definitely not okay with the FAIP course for a number of reasons. One is he's not been convicted of anything, and I think it is unlikely, based on what he told me, that he will be. The other thing is he's only 23 years old and he's working to support his two children. He shares two rather young children with the alleged victim, Your Honor. I believe one of the children, one child is just 2 years old and the other child is 5 months old. So these are really, really young children. So because of that, I would like his bond to be conditioned on no further violent contact, not because he intends to go back and live with the alleged victim, because he has told me that he does not. But they do share two children, and it is important that this father be able to be fully involved with the children. So that is the basis on which I'm asking for no further violent contact, because of the two very, very young children that they share together. Plus, my client has no history of violence. And he has already told me that the plan is he will not be living there. He will be moving out going forward. So nothing further, Your Honor.
All right, we do want to make sure that the children and the victim are safe. And I'm certainly going to order that he stay away from that location.
He plans to, Your Honor, but he does need to go and get his belongings because that's where he lived.
Okay. So I'll order the $5,000 signature bond through pretrial. I'm going to have him be at a level 1. I'm going to order the 5 anger awareness courses. And I don't know with the parenting class if it's free or not.
They are not free, Your Honor. I do a lot of family law as well, and I can tell you that those parenting classes are not free. I had the opportunity to speak with my client. He has no history, and the warrant shows that, it wasn't like he was on his own with this. He denies that he was the one who initiated it, actually, and the warrant actually states that he was struck by her too, and so on. So it's not like he's just some random person who just starts hitting on people. That is not his temperament at all.
Right.
John,
Well,
I do believe that the warrant says that she hit back when she was.
That's what the warrant says, but he tells
she
me
did.
that's not
But
what
she did.
happened.
I didn't cut you off, Ms. McLeod, so don't cut me off. I believe that she was acting in self-defense, and I do believe the fact that he carried on this way in front of the children, and based on the phone call that I heard between the two of them, I'm not saying that he shouldn't have contact with his children, because I would never do that. I am not. This is not family law nor family law court. I do believe that a parenting course would better facilitate his engagement with those children in terms of how he's acting around them. It is not free, Your Honor, but through AACS, it is discounted through our office, but it is to better him. Unfortunately, with some of these bond conditions, when a defendant finds himself in this position, not all the things are free. And I gave an example of that earlier, like an ankle monitor isn't free. This is a serious charge. And I do believe that since Your Honor is not going with the FVIP, the intensive 6-month FVIP program, that at minimum, the 5 anger awareness plus a parenting course, which is not as expensive as an ankle monitor, would only strengthen this defendant in his parenting of these children.
Did you say he was working, Attorney McLeod?
He is employed, Your Honor. Yes, he does work.
Okay. And the children, they're young, they're minors. We're just trying to ensure, I guess, that going forward, that everyone will be safe and be in a better environment. And although he has no history, we want to make sure that this is the first and last action or allegations of this type. The 5 anger awareness courses, I think, will be fine for now. And I know that ASG Rhodes mentioned a discounted class for the parenting class. I don't know if that
Yes.
would be feasible at this time.
Yes, it's through AACS. It's one of our vendors that discount parenting courses for us. As a matter of fact, if you do it through Operation 21, I will make sure that it's free through Operation 21. Although that's not always the case, though, Your Honor.
Right, right.
Some of these, that's what it is, Bond isn't free.
Mm-hmm. Right.
I understand Prosecutor Rhodes, but the fact is, my clients generally don't have money like that. So $40, $50 here, it's significant for them. It might not be for many people, but he's a young man. He's, I believe, just 23 years old. So he doesn't have a lot of income like that. If the class is free, then we don't object to it at all.
Okay.
Because it is helpful. The parenting class.
All right. If the class is free through Operation 21, I will require him to take the parenting class.
I will contact Operation 21 to make sure that it is free for this.
Okay. All right.
Thank you.
All right. We'll do that. And he is to stay away from the incident location for now with a one-time law enforcement escort to return to get his personal belongings. And no further contact with the victim. If there is visitation with the children, that should be facilitated by a third party. Although I'm inclined to say no visitation with the children. But at least if it's with the third party and, no further violence in front of them of any sort, then he can visit with the children. No drugs, alcohol, weapons, or guns while on bond.
Thank
That's
you,
it.
Honor.
All right. Thank you.
Thank you, Your Honor.
Your Honor, what's the breakdown on that?
3,000 on the battery family violence, 1,000 on each of the cruelties.
All right, next we'll go on position number 13, Mr. King.
Okay. This is 26 CR 0000357Y. Timothy King, charged with two counts of criminal trespass.
Judge, 8 cycles, FTA in 24, driver while license suspended in 24, battery family violence in 23, criminal trespass in 16. There's an open case for giving false name and driving with a suspended license out of Forest Park from 11/25/25. His last arrest was 12/11/25 out of Henry for a probation violation. Nothing further.
Thank you.
Yes, Your Honor. This incident is from October 20th of 2024. Officer Fenn responded to 6300 Oakley Road in Union City and spoke with Keisha Wood, who advised that her then ex-boyfriend, Timothy King, kept returning to her residence and kicking in the door. Officer observed a broken door frame and broken hinges that prevented the front door to be secured. Officer Fenn had been dispatched to the same address approximately 3 additional times on the same night for the same type of incident. But each time the defendant was gone from the location. The same day, Officer Brianna Benson was dispatched to the same address. The victim advised that the defendant threw a rock at her window and the window was shattered. Your Honor, based on the FTA, the battery conviction, the 2016 criminal trespass conviction, the state's recommendation is a $1,000 surety bond. We understand the victim is here. If we can sound for her, if she wants to be heard. And I'm so sorry. I'll continue with the recommendation. It's a $2,000 surety bond. No further contact with the victim. Stay away from the incident location. No alcohol, drugs, or weapons while on bond.
All right. And what was the no further violent or no
further contact.
No further contact. Okay. All right. Attorney McLeod?
Yes, Your Honor. I understand that based on the FTA that he does not qualify for a signature bond, Your Honor. But I would ask the court to give him a lower surety bond than the $2,000 that the state is recommended. At first, the state had said 1,000, but then I heard 2,000 at last. The 1,000, I believe, is more appropriate, Your Honor, given the fact that this case is almost 2 years old. It's according to the warrant, it happened in October of 2024. We are now in 2026. There's been no other issues between them. That is my understanding. I believe the state said that the alleged victim was on. I did not get a chance to speak with her.
Yes, I am. I'm here.
All right, put on your camera. All right, and is it Keisha?
Keisha, yes.
Keisha. All right, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. Are you still in fear of Mr. Timothy King?
No, ma'am.
Do you want to have any further contact with Mr. King?
Yes, ma'am.
Do you all still have children? Or do you have children together?
No, ma'am.
Okay. And have there been any incidents between the two of you since this incident?
No, ma'am.
Okay. All right. I don't have any other questions to state.
No, Your Honor.
All right, Ms. McLeod.
Yes, Your Honor. So based on what the alleged victim is saying, Your Honor, she is corroborating what I was saying, that this was a one-off incident between them and they're perfectly fine. And my client tells me, you know, they're fine at this point in time. It's a very, very old case. So I think, you know, an appropriate bond, as low a bond as possible, Your Honor, if he does not qualify for a signature bond.
All right. I thought the state recommended, or they stated there was a preset bond of 1,000, or the state recommended 1,000.
I am not sure if there was a preset. The state's recommendation was a $2,000 surety bond.
Okay, it was 2. Okay.
Yes, and I was asking for no more than 1,000, Your Honor.
I got you. Okay. All right, you can mute yourself, Ms. Wood. All right, I will order the $1,000 surety bond, 500 on each of the charges. With that $1,000 surety bond, I guess there's no, and I didn't add, well, no further violent contact with the victim, based on her testimony, and no drugs, alcohol, weapons, or guns while on bond.
Thank you, Your Honor. And that concludes my business before the court today. May I be excused?
Yes, you may. Thank you.
You're welcome. Have a good day.
You too.
Thanks.
Next, we have position number 10, Mr. Green. Green, come on.
Your Honor, as it relates to Jeremiah Green, I do believe it is a consent bond.
All right, thank you. This is 26 CR 000-368A. And Mr. Jeremiah Green is charged with 1 count of willful obstruction, 2nd count of giving false information. The terms of the consent bond.
It is as follows: $3,000 signature bond through pretrial services level 1. The breakdown of that bond is $1,500 on each charge. That is the willful obstruction and the giving false information to law enforcement officers. So $1,500 each for a total of $3,000 through pretrial services level 1. we're asking that as a result of the bond, that he go ahead and condition of the bond, that he takes a law and decision-making course through Operation 21, that he stay away from the 4485 Washington Road, East Point, Georgia address, and that he's to have no alcohol, drugs, or illegal weapons while out on bond. Thank you, Judge.
All right,
And Your Honor, I am in receipt of that order.
great.
That's
Mr.
correct, Your
Martinez?
Honor. That is correct, Your Honor. We appreciate the state working that out. And I've talked about that with Mr. Green, and we're in agreement with the terms.
Great. All right, thank you. I'll sign that order shortly.
Thank you, Mr. Bartell.
Thank you. Thank you, Mr. Rhodes.
I'm sorry, what's that amount again?
It is $3,000 SOB pretrial level 1, 1,500 on each.
Gotcha.
Mm-hmm.
Good. Next we'll go position 25, Mr. Williams. Williams here? Henry Williams. That's it.
This is 26 CR 0000354J. Henry Williams, charged with 1 count of criminal trespass and damage to property. 2nd count, possession of marijuana less than an ounce.
Morning, Your Honor.
All right.
Just a second, Judge. My notes did not save on Mr. Williams. Give me just a second.
Okay.
Your Honor, I have the criminal history.
Okay.
He has 1 cycle in Florida, 1999, receiving stolen property, 19 cycles in Georgia, a criminal trespass from 2000, simple assault, theft by taking, a 2004 forgery and burglary, a 2006 criminal trespass, 2009 aggravated assault, and 2014 battery. Your Honor, on January 15th, 2026, Officer Livingston responded to 596 Rockwell Street Southwest for a criminal trespass call. The complainant is Brendan Hardwick. He stated that he left his room locked around 8:30 a.m. He then received a camera alert showing his roommate, the defendant, Mr. Henry Williams, entering his room and going through his belongings. When the victim spoke through the camera, the defendant put the items that he was taking down and left the room. Once the officers arrived at the scene, the victim showed them damages to his door and lock. The damages prevented the door from being secured properly. The officers conducted a search of the defendant to make sure he did not have any items from Mr. Hardwick's room and found less than 1 ounce of marijuana in his pocket. The state's recommendation is a signature bond through pretrial services and further contact with the victim, Mr. Hardwick, to stay away from the incident location, 596 Rockwell Street Southwest. No alcohol, drugs, or weapons while on bond.
And what was the amount of the recommendation? It was a signature bond through pretrial level
Yeah.
1.
Yes, Your Honor. The amount to 1,000.
All right.
Yes, Your Honor, we would ask that the court consent to the signature bond request. And I'm so sorry I missed it. Is there a do not return? If so, we would just ask that he be able to return one time to get his belongings.
All right.
He has a surgery and a bunch of medical things coming up, and he said that he would be able to stay elsewhere.
Okay. I'm going to order a 1,500 signature bond, 1,000 on the trespass, 500 on the marijuana. So 1,500 signature bond through pretrial level 1. Stay away from the incident location. one-time police escort to return to get his personal belongings. And is it no further contact with the victim? And no drugs, alcohol, weapons, or guns while on bond. And that's it.
Thank you, Your Honor.
Mm-hmm. Yeah, next.
I'm sorry, I was on mute that whole time.
No.
Position number 20, Ms. Smith.
Okay. This is 26 CR 000-377J. Shaquira Smith charged with 1 count of battery family violence and 2 counts of cruelty to children in the 3rd degree. Pretrial.
Only prior arrest is a contempt of court in 2018. If you choose to release her, pretrial recommends a UJR jail. Nothing further.
All right. Dave?
Yes, Your Honor. On January 16th of this year, Officer Mason responded to 2612 Steel Avenue Southwest, apartment 26A, for an injured person following a domestic dispute. The caller, Demario Jones, had a deep laceration above his left eyebrow. Mr. Jones stated that the defendant, Ms. Smith, who is the mother of his 2 children, ages 4 and 1, became upset after he had no more money to give her. When he attempted to cook noodles, Ms. Smith threw them away twice. She then struck him in the face with the cooking pot, causing the injury. This incident happened in front of both kids. The parties live together. They have been dating on and off since 2019. Your Honor, the state's recommendation is a $2,000 surety bond, $1,000 for the battery family violence, and and $500 for each cruelty to children count. No further contact with Demario Jones, and stay away from the incident location. No drugs, alcohol, or weapons while on bond.
All right. P.
Thank you.
Bronstein.
Thank you, Your Honor. Ms. Smith is 31 years old. She was born and raised in Atlanta. Her whole family are here, and she has 5 children, ages 10, 8, 6, 4, and 1. She does work. She went to some college. For this case, what she told me is very different than what the state said. She told me that the complaining witness in this case is regularly violent and that she was defending herself. Also, she said that it is her name on the lease, not his. And with all the children, it'd be very difficult for her to find a long-term housing situation. So we would ask that if he is no longer there, that she be able to return to the location. And if not, that she at least be able to get her belongings. We are asking for a signature bond based on her lack of criminal history.
Your Honor, we were not able to contact the victim, so we cannot confirm whether the lease is on her name or the victim's name. But he did have a deep laceration to his face. And so since we have not had any contact with the victim, we are asking for the stay away and no further contact.
I guess that's a question, I don't know, for the defendant with her having the 5 minor kids. Is this her place or his place? Well, it says the two of them were living together on and off since 2019.
Yeah, she said she was the only one working and that it's her name on the lease. Basically, what I'm asking is if he's no longer there, that she be able to return. And then if not, she can go through eviction proceedings. Or the owner of the place can go through eviction proceedings.
And usually what I say is they can return with police escort, sweep the property. If the victim still has items there, as if he lives there, then she cannot return until he has vacated, if that happens. Otherwise, she and her children, I guess, must reside somewhere else. So let me start with, I will order the $2,000 surety bond. And I'm sorry, $2,000 signature bond through pretrial, level 1. And with that signature bond, the 1,000 will be on the battery, 500 on each of the cruelty charges, so a total of 2. And like I say, she must take a police escort back with her to the Seal Avenue apartment, sweep it and see whether she can stay or not. The defendant doesn't reside there. I'm sorry, the victim doesn't reside there. No drugs, alcohol, weapons, or guns while on bond. And I'm going to say no further violent contact with the victim. And if there's visitation with the children, if they're his children, then that be facilitated by a third party.
Thank you, Your Honor.
And I think that'll be it.
Next, we got position 21, Ms. Stevens.
Okay. This is 26 CR 000379E. Yasmin Stevens, charged with 1 count of criminal trespass and damage to property. And pre-trial?
Judge, in regards to Ms. Stevens, one is opening. Ms. Stevens, 2 cycles, open aggravated assault, criminal damage to property. In Fulton, 25 PI 004225. Victims are Mr. Khalil, Khallee, Morrow, and Sapphire Abrams. And that's from 5/28/25. Nothing further.
Okay. State.
And this is Yasmin Stevens.
Yes.
Oh, my apologies. That's me. Stevens.
Okay.
One moment.
While she's looking at it, Your Honor, can I ask Ms. Chastity Colbert to respond to the chat?
Okay.
Yes,
Thank
ma'am, I'm here.
Respond to the chat, ma'am. Please do
I'm
not
here.
speak.
I'm
Respond to the chat. Do not speak. Thank you.
Yeah, just one moment. My apologies.
Okay.
All right. On December 13th, 2025, Officer Hendricks with the Union City Police Department was dispatched to 5204 Rosewood Place in Union City, Georgia. Upon arrival, he spoke with the complainant, Donna Benny, who reported that her son's ex-girlfriend, Jasmine Stevens, came to her residence in an agitated state and damaged her property. She uprooted garden plants, knocked over Christmas decorations, and texted Vinny claiming that she urinated on a package that was left at their front door. On scene, the officer observed uprooted plants, displaced decorations, and liquid on the front doormat, but he could not confirm what the liquid was. The victim provided screenshots of text messages from Stevens, including threats of ongoing property damage. Your Honor, the system, when I checked the system, it showed that she had an active warrant from East Point for terroristic threats and acts. She also has an open case for aggravated assault and criminal damage to property in the second degree. So the state's recommendation is a $1,000 surety bond. No further contact with Donna Vinny or the ex-boyfriend, Mr. Vinny, to stay away from 5204 Rosewood Place. Not drugs, alcohol, or weapons, swallow bond.
All right.
Thank you, Your
Pretty
Honor. I
interesting.
spoke with Ms. Stevens. She's 32 years old, is from Atlanta. Family's here, siblings, aunt, daughter, is 4 years old. She is unable to work due to several health issues that we went over. Court can see cast on her arm. Essentially, she's with the other case the state cited, it's her boyfriend or now ex-boyfriend is very violent, and that is how her arm got broken. She just wants the court to take this into consideration. She is going to be getting away from him, and understands the concerns about this case, but did want to stress that she is unable to work due to her many health issues. She gave me several diagnoses. But I went into the boyfriend because I believe he's the party with the other case that the state brought up.
Think there's a different case or a dual arrest?
Your Honor, I'm checking right now. Give me one moment. This is even. I'm sorry, Your Honor. It's a Superior Court case and it's not giving me access to some of the documents. Just
You wanted to know the victim name in the Superior Court case?
Yes.
It said it's Khalil Morrow and Sapphire Abraham.
Right. She stated them. I thought you all were looking up some other case. I want to move on if we.
Yes, Your Honor. I'm not sure if this case is related to if the victims in the Superior Court case are related to this case.
You find anything, Attorney PD Bronstein?
Well, I thought that the complaining witness in this case was the boyfriend's relative, and that's what I thought they were.
Okay. Anything else before I make my ruling?
No, Your Honor.
Okay. All right, I'm gonna order the $1,000 surety bond. I'm going to order no further contact with the two victims in this case. I'm gonna order stay away from 5204 Rosewood Place. And no drugs, alcohol, weapons, or guns while I'm bond. That's it.
Thank you, Your Honor.
Mhm.
Next, we have position number 8, Mr. Faust.
This is 26 CR 000-365E. Marcus Faust, charged with 1 count of simple battery, family violence. Pre-trial.
Just a second, Judge. Let me pull that one up. Faust. Judge, in regards to Mr. Faust, 13 cycles, 4 FTAs, 22, 22, 21, and 19. Probation Chatham for aggravated assault, 2 counts, carrying a weapon in a school safety zone from 10/19/18. It was a first offender that was revoked. Resentenced to 12 years. He's on probation out of Clayton for cruelty first, criminal trespass, and simple battery, sentenced in 23. 2 years confinement, 10 years probation. His last arrest was out of Clayton, a simple battery that was dismissed in 23. Nothing further.
All right.
Excuse me, well, what position is this?
Number 8.
Number 8. Okay, thank you.
Mhm.
Yes, Your Honor. This is a incident that occurred January 16th of this year at 140 Wolf Downs Court in South Fulton, and involved the victim in this case, who at the time of this incident was in fact with child. Given what you've heard as it relates to the criminal history in this case, many of those cycles, Your Honor, I'm showing a total of over 20 cycles. Many of them were violent in nature. There were several FTAs, current probation. We are recommending a good bond in the amount of $2,500. We are asking that at this time that he has no further contact with the victim in this particular case, who is Miss Dominique Wilson, and that he will stay away from the incident location of 140 Wolf Downs Court, South Fulton, Georgia. This is an incident that alleges that at the time of this attack, she was in fact, as I said earlier, with child. It gives us some cause for concern. So we are asking that he undergo the 24-week of family violence intervention program, at least get it started. And that is the state's recommendation, Your Honor. Thank you.
Mhm.
Yes, thank you, Your Honor. I have spoken with Mr. Faust. He wants the court to know, well, he did call the police. He denies putting his hands on Ms. Black, I think it's Blackshear Wilson. I think it's Wilson Blackshear, yes, a compound last name. He did indicate that she did take his keys from him. That's why he called the police. He indicates that there is a video available that can substantiate his side of the story. However, I advised him that that will come into play on down the road. He was born in Atlanta, Your Honor. He's lived here all of his life. His parents and his siblings and extended family live in Atlanta. I'm advised that he's employed part-time as a mover, and he also goes to UEI trade school where he is studying auto mechanics. So he has ties to the community. He is wanting to ask the court for a signature bond if he qualifies. If he does not qualify, we would ask for a $1,500 good bond, and nothing further at this time.
All right. Given his extensive history in FTAs, I'm going to order the $2,500 surety bond. stay away from the incident location, Wolf Downs in South Fulton. No further contact with the victim, Dominique Wilson. And no drugs, alcohol, and weapons while on bond.
All right, thank you, Your Honor.
Uh-huh.
Oh, that amount was $100?
No, 2,500.
Oh,
Victim said she did.
2,500.
The victim said she want to do the no violence. She didn't want to do the no contact.
No further violent contact.
Yes. Well, I'm saying, why I can't go there though? That's my baby mom. She pregnant. I'm the only one that paid the bills.
Well,
That's-
but you had an incident, so I've ordered you to stay away, find somewhere else to live. If you need a one-time escort to get some personal items, I will do that. But you
And just,
cannot
Your Honor, I
go
would-
back there. Yes.
I'm sorry, Your Honor, I didn't mean to interrupt.
Hold on, there's somebody else is talking who doesn't have permission to talk. I asked ASG Rhodes to speak, want the defendant to be quiet, and is the victim on the line?
Yeah, she's talking.
Okay, then the victim needs to be quiet right now, not ask her to speak, and I need her to turn on her camera if I allow her to speak.
Yes, Your Honor, thank you. And my apologies, because I don't know if Your Honor was completely done talking. What I was going to say is that, in addition to the stay away, that instead of no further violent contact, the state is asking for no further contact.
That's what I was under the impression.
Yes, Ms. Bridgewater, and I do understand that the victim may have a different opinion, but considering the allegation here, the injuries that the officer observed, the state may very well escalate these charges from simple battery to battery family violence, which are more serious. And
Okay.
the fact that she was pregnant at the time, police did have to be called. And we do have cause for concern, and we do believe there needs to be a cool down period. Thank you, Judge.
All right, thank you. And I'm
Good.
sorry, I probably meant to say no further contact instead of no further violent. And the victim, if she's on here, turn on your camera, please, ma'am.
Yeah, and we were requesting a no further violent contact, Your Honor, especially based on what Ms. Wilson says, but I think she can speak.
I can't turn on my camera.
Then I can't speak to you.
No, it won't let me turn it on.
Well, that means you signed in without.
Oh no, it's on there.
All right, raise your right hand for me. Do you affirm the testimony you're about to give is the truth, nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right. Are you in fear of Mr. Faust?
No, ma'am.
You want to have any further contact with him?
Yes, ma'am.
And you're pregnant right now?
Yes, ma'am.
And you were pregnant when the incident happened?
Yes, ma'am. But nothing was physical. It wasn't anything physical that happened.
But did you call the police?
No, he did. He called the police. And because he was just the aggressor in the situation when the police got here, that's why it escalated. It was never me and him got physical. He never put his hands on me.
Okay. All right. Well, my ruling, and I just wanted to give you that opportunity to speak because I didn't know you were on the line. But it's a $2,500 surety bond. I'm still going to order the stay away for the cooling down period. And so he and his attorney can apply for modification of that bond condition. I will allow, if he gets out on bond, one-time police escort to return to the property to get any personal belongings that he might need while he's out of the home on bond. No further contact with you, and no drugs, alcohol, weapons, or guns while on bond.
But what about the doctor's appointment and stuff? Like,
she'll have to figure out how to make them there by herself right now. I'm going to make sure it's a cooling down period, that there will not be any more escalations for someone to get hurt any more serious than they were. So that is going to be the order of the court so that the two of you can cool down. This has happened less than 24 hours, probably.
I should say simple battery by touch because I got reach for my keys.
Next, we got position number 1, Mr. Bard.
All right.
You don't worry about that. I got one. All this money.
This is 26 CR 000-376C. Victory Barnes, charged with 1 count of driving while license suspended or revoked, expired tag or unregistered vehicle, knowingly driving a vehicle on a suspended or revoked registration, obscured or missing license plate, seatbelt violation, and giving false name or information to an officer. Pretrial?
Your Honor, before pretrial goes on, I actually just submitted a no pros to the court. This case is also open in Superior Court.
Oh, okay.
And so, yeah, we submitted the accusations, but we just submitted a no pros, so Superior Court can handle it.
No,
right,
no
thank you.
objection, Your Honor. Thank you.
Okay, thank you.
And Your Honor, for your record, I can't get it out. I just received that null process, so.
Great. Okay, thank you.
Yeah, I was wondering about that. Thanks.
What was his ruling? I'm sorry, I was distracted.
No pros, cases in Superior Court.
Okay.
Dismissal.
Dismissal. Next we got position number 11, Mr. Jackson.
All right. This is 26 CR 000-371Y. Sean Jackson, charge of 1 count of battery family violence.
In regards to Mr. Jackson, 4 cycles out of Georgia, only violence is an aggravated assault, battery, 2 counts, and firearm doing from 04. Nothing further.
All right.
Yes, Your Honor. Yes, Your Honor. This was the case where I was trying to get in contact with the victim that is on the Zoom, I believe. I did have a consent bond. Let me see if I can.
Yeah.
1 second here. That was
Okay.
just. I'm sorry. Thought I had it.
Do you have it, Mr. Bartell?
I do, Your Honor. And I think we were pretty much in agreement except for one term, which would be a stay away order. And the recommendation was $3,000 signature bond pretrial level 1, 5 anger awareness classes, no further contact with the alleged victim, Ms. Colbert. She was on the screen a while ago, but I don't see her anymore. A stay away from the location and no alcohol, drugs, or illegal weapons.
And that is correct, Your Honor. And the purpose of the no further contact and the stay away is because the victim witness advocate did attempt contact with Ms. Chastity Colbert, and we were unable to reach her to kind of get an idea. So I did ask her to chat with me, but she I don't think she understood that I was in a private chat. So.
A private chat, you're right.
And I guess
and she's still on. She's not on. Who's my Zoom master?
Not me, but I don't.
Oh, is that Mr. Jordan?
Mr. Jordan, Mr. Jordan is.
Do you see her on, Mr. Jordan? Did she get back on or she got off?
She's logging on now.
She's logging on now? Okay.
And Your Honor, I guess the thing we were curious about is there's no issue with a no further contact order, but we need to figure out if she is going to be living at this address because this is his home and he's paying all the bills. And he's under the impression that she's going to be living somewhere else. So I guess we were going to ask for him to be able to live at that address unless she is also there. And maybe she could clarify.
Okay. Miss Colbert, are you on yet?
So it just says that she's joining. She's probably just having internet issues.
And yeah, because it's just circling or something.
If it helps, Mr. Bartels, in Your Honor, I can put in stay away from 715 Holmes Court, Northwest Atlanta, Georgia, unless the victim has clearly moved.
Right. Well, let's do that. Err on the side of caution, Mr. Bartels. He can go back with a police escort. He makes bond and gets out with the signature bond. Obviously, he will. So what that will mean, Mr. Jackson, put your hand down for me. so that you can listen to me. What you need to do when you get out is to arrange for a police escort to take you back to the property. Do not go back by yourself. But you can tell them it's a part of your bond order and that they will escort you back. They will sweep that property to see if there are many belongings there for Miss Colbert where it appears that she's still residing there. If she is still residing there, you cannot stay. Maybe she needs another day or two to get out and then maybe arrange to go back in a couple of days when she has vacated the property. But we have to give her an opportunity to do that as the victim in the case. All right. And then once she is vacated, then you can return to the property. But for right now, you should stay away until you've had that officer's escort to determine that. And then no further contact with her once she has moved while you're on bond. You have to take those 5 anger awareness courses as well. And they're free through pretrial services.
All right.
Did you have a question, sir?
Yes, sir, I do. I am in default right now because I owed $100 on the 16th. I had just paid $1,100 toward my rent. I owed another $100, so I am in default for an eviction. So it was a note posted on my email that if I didn't pay it's going to be evicted. So I would need to get a U-Haul and get all of my stuff out because I have dogs that live with me. So that means my dogs will be thrown out on the street too, and that's what I don't want to do.
Well, you'll be out within 24 hours. When was $100 due?
It was due the 16th.
Oh,
Yeah,
yesterday.
So, default of, and it strictly says if it's not paid, we are able to come grab all your property and throw it out. That's stated on my lease. She doesn't know.
Well, she may be gone and you may be gone, unfortunately, because you're here.
I definitely understand that.
Yes.
Well, I still think on the side of caution, when you go back with the U-Haul truck to get your items, if they're still there, you call and ask for a police escort because of your bond condition, because you certainly don't want to go back, even though you're removing your items and she may still be there doing the same, and then you end up back in jail. So I know you don't want that. So you've got to arrange for the police to meet you there.
Yes, she has a few bags, Your Honor. The whole furnish is mine. Couches.
Okay, well, hopefully it's all still there and you can get it, okay?
All right. I'm just saying it's not an easy process to move.
Sir, yeah, just go ahead and do what you
Yeah,
can.
I'm not in control of that. I'm just trying to make sure you don't end up back at the Fulton County Jail. That's all.
Yeah.
Okay.
Thank you, Judge.
Thank you.
Good luck, sir.
And that bond order was sent to Ms. Bridgewater with the amendment. Thank you.
Okay, thanks, Mr. Woods.
He's got a signature bond?
Yes.
And I just received it, Mr. Rhodes.
Thank you, Ms. Bridgewater.
That was the jail,
Thank
I think. 3,000.
3,000.
Yes.
Level 1.
Okay.
All right, you're good. We go position number 12, Mr. Jones.
This is 26 CR 0000374C. Samad Jones, 1 count of driving, fleeing, or attempting to elude, driving while license suspended or revoked, willful obstruction, and no insurance.
In regards to Mr. Jones, 7 cycles, 6 out of New Jersey. There's a robbery in 2017. Only prior Georgia cycle is took a pending PTI on a cruelty and a battery family violence from 8/7/25. If you choose to release him, pretrial recommends UJR jail.
All right.
Yes, Your Honor. This incident is from January 16th of this year. Officer Golden observed a red Dodge Charger with no active insurance. The driver was a slim, light-skinned male with facial tattoos, did not match the registration. The registered owner of the vehicle, which was Monica Jones. When the officer activated the emergency lights and sirens near Fouts Road, The vehicle failed to yield and continued eastbound at approximately 50 miles per hour. The pursuit was canceled per supervisor since the vehicle crossed over the lines into Gwinnett County. Gwinnett County PD was notified. Using law enforcement database, the driver was identified as Samad Jones, who shared the address with Monica Jones. Gwinnett officers located the vehicle at 1404 Hunter Ridge Lane, and found Mr. Jones there. At first, he gave conflicting statements about who was driving the vehicle. However, surveillance footage placed the vehicle and Jones at the residence shortly after the incident. Monica Jones confirmed that Samed Jones was the one driving the vehicle. Your Honor, the state's recommendation is a $3,000 surety bond, $2,000 for fleeing or attempting to elude, $500 for driving while license is suspended or revoked, and $250 for the willful obstruction and for the new insurance charge. No driving without a valid license, no drugs, alcohol, or weapons while on bond.
All right. PD Bartels?
Yes, thank you, Your Honor. I have spoken with Mr. Jones and looked at the warrants. Mr. Jones, he indicated that the car did belong to his wife. He wasn't aware that there was no insurance on that. It also took him, he did not realize immediately that he was being pulled over. I don't think the warrant indicates how far he's alleged to have gone. But anyway, he does work full time. Your Honor, he works at Boston Scientific, which is a medical supply company. He works in sales. He's lived in Georgia for several years, so he does have ties to the community. We are asking the court to consider a signature bond if he qualifies. Otherwise, we would ask for a $500 good bond on each charge for a $2,000 bond total. And that's it for now.
Is he on, what was the 8/7 25 PTI and something? What was that?
Yes, Your Honor, this is a disorderly conduct, battery, family violence, and cruelty to children in the third degree.
And that's Bolton?
Gwinnett.
No, Gwinnett.
Oh, Gwinnett. Okay, gotcha, Gwinnett. All right, I will, and normally, depending on the history with these charges, I will give him a $3,000 signature bond through the jail. 2,000 on the driving and fleeing, 500 suspended license, 250 for the obstruction, 250 for no insurance. With that signature bond through the jail, he is not to drive unless he has a license and insurance or all the proper requirements to drive. No drug, alcohol, or weapons while on bond. And I think that's it. Anything else?
Nothing from defense, Judge. Thank you.
Okay.
We go to position 22, Judge, Mr. Todd.
All right.
My apologies, Your Honor. What position is this?
22. 26 CR 0003488H. Casadera Todd. One count of battery, family violence.
Judge, in regards to Todd, 10 Cycles, Florida, there's a prior conviction for battery on a facility employee in 22. 2 Cycles, Georgia, there was a battery that was dismissed. It was a Gregory Perry. Maryland, didn't put down the number of cycles, but there's a prior assault conviction in 17 and 16. Open criminal trespass out of Gwinnett from 11/15/25. Nothing further.
Okay.
Your Honor, this incident is from January 15th of 2025. I'm sorry, let me double check.
I have 2026.
Yeah, yep, 2026. My apologies. Officer Klutz responded to 400 Fairburn Road Southwest, apartment A8, for a dispute involving the defendant and Donna Murray, who's 77 years old. She stated that her nephew, the defendant, has been living with her since June of 2025. She stated that the defendant struck her in the face with a fishbowl and punched her multiple times after she told him to leave. The defendant, I'm so sorry, officers observed swelling and discoloration to the victim's face. Based on the criminal history and the facts, the state's recommendation is a $3,000 surety bond, no further contact with the victim, and stay away from the incident location, and no alcohol, drugs, or weapons while on bond.
All right.
Your Honor, I was able to speak to Mr. Todd. The jail called me. So he is 30 years old. He is from Atlanta. His family is here. As far as the money goes, he really does not have much. He does landscaping for himself for work. He did say that if there was a do not return or a no contact, that he would be requesting a one-time police escort to gather his belongings. We are just asking for a lower bond than $3,000 that would be quite high for him.
Well, with his history and according to the allegations, which are a little disturbing, I'm going to order the $3,000 surety bond and order him to stay away from the Fairburn Road location. No further contact with his aunt, Miss Moray. No drugs, alcohol, weapons, or guns while on bond. And that's it.
And I'm sorry, Judge, it went out and you said how much?
Oh, I'm sorry.
Again?
$3,000 surety bond. And then the one-time police escort to get any personal belongings. Stay away, no further contact.
You got position 19, Mr. St. Louis.
This is 26 CR 0000369Y. Jim's St. Louis, charge of 1 count of harassing communications, 2nd count of stalking.
Judge, there's a hold for FTA out of Jeffersonville, 9/3/25, 16 cycles, FTA and 20. Possible open misdemeanor for possession of marijuana out of Hall from 12/20/20. He's on has open felony out of Fulton, financial transaction card theft, 2 counts, 25 SC 00715. Nothing further. Okay.
Yes, Your Honor. This incident is from February of 2025. Officer responded to 7445 Trowbridge Road in Sandy Springs, Georgia, regarding a domestic dispute. The victim, Danielle Logan, reported that her ex-boyfriend, Jim St. Louis, was outside her residence and refused to leave. Officer found him in a silver SUV outside of the residence. The victim stated that she felt unsafe due to weeks of threatening text messages from him, where he was threatening to cause her physical harm if she did not do what he requested. The officer did review his phone and he saw numerous text messages sent. The victim never replied. He was instructed to leave and not to return without permission. Approximately 10 minutes later, the victim received a text from the defendant stating, "Police ain't going to stop nothing. Send them that too." Your Honor, based on the criminal history and the facts, the state's recommendation is a $2,000 surety, $1,000 per charge. No further contact with Danielle Logan. Stay away from the incident location. No firearms, weapons, or alcohol while on bond.
All right.
Your Honor, as the state stated, this case is almost exactly a year old. I did not hear of any instances with the other party since. Mr. St. Louis is 34 years old. He is from Atlanta. His family's in the area, mom, sisters. For work, he does work as a subcontractor. I asked about his living situation. He says that he and the complaining witness do not live together, but that they do co-parent their son and that they've been fine for the past year since this has happened. So if the court does do a no contact, we would ask that there at least be a provision for him to be able to see the child. Additionally, considering the age of this case, the fact that there have been no instances since, and the fact that he is a hold, we'd be asking for a signature bond to the hold so that he can go ahead and handle that.
And that hold is a FTA out of Florida.
Is that a Florida?
Was it?
No, Jeffersonville.
It's close to Myrtle Beach.
Is that Jeffersonville, Georgia?
Like close to Myrtle Beach. I was coming from Myrtle Beach. It's like a one-time thing.
No, I didn't ask for the specifics. I just asked the location. Jeffersonville, South Carolina.
Yeah, like Savannah, like close to Savannah.
Oh, to Georgia.
Is Georgia.
Is Georgia. Okay. I'm just trying to figure out if they'll come and get him or not.
I'm not sure. I'm not.
Let me look what it's.
That wasn't a question for you, sir.
As far as extradition.
Mm-hmm.
Well, since it's in the state.
Some of them still have a mile
That's not
radius.
necessarily. Sometimes they sit there and then they let them go because they don't come get them.
Okay.
Don't. Especially sometimes the farther away they are.
Yeah, it doesn't say on here whether or not, on the GCIC, whether or not they'll come pick him up. I'm going to look under the booking and see what it says.
Okay.
Oh, wouldn't there be something in Odyssey?
Yeah, on the one that they put in the booking report should say whether or not it'll come pick him up or how far they'll come pick him up.
Mm-hmm.
Just a second. Okay. St. Louis is valid tracking. It doesn't say how far they will come. It's just saying if they're not going to come get him, it'll be just on there for 72 hours.
Then after that, the jail can let him go.
Yes, Judge. They have 72 hours to pick people up on holds.
Yeah, I'm not excited about that one. So I'm going to give him a $2,000 surety bond, and with that surety bond, it's $1,000 on each of the charges, because those are pretty serious charges. Stay away from the incident location. No further contact with the victim. And there was a child involved.
No, ma'am.
Not involved. They have a child that they co-parent.
They have a child. So if visitation is allowed with the child, then it must be facilitated by a third party so that he doesn't violate his bond conditions. I want no, I know it's been over a year, but I'm just, if you all have not talked to the victim state, I don't know about no further contact or no further violent contact. Have you talked to the victim?
Your Honor?
Yes. Have you all spoken to the victim?
No, we did not have contact with the victim.
Okay, so I'm gonna order since that no further contact. 1 second, Mr. St. Louis, what are you gonna state? I don't know if your attorney wants you to say it.
I was gonna say that we on good terms. I still talk to her. That's just my son child. So if she knew I was locked up, she would be on court. It's just I did not even know I had a
Well, if
warrant.
you're on good terms, why would she know? How old is your son?
My son is 8 years old. Like I didn't even know I had a warrant. This warrant been out for a whole year. Like I did not even know. And I've talked to her after after the incident a year ago, and I've been seeing my son and everything. She stays in Kentucky, Louisville right now, because they had to move. Like, but we still communicate because we have a child and stuff like that. It's like, there's no problem, nothing. That's why I'm just confused why I even have a warrant in Sandy Springs for this.
Well, a lot of times there's a warrant out. You may or may not know till they find you or can effectuate the arrest.
Yeah, but I be around them and everything. That's why I was like, if I knew I was gonna get locked up for this, I would have had her be on court with me, like, so she could clarify, like, it's no problem, but
Well, she may not be able to clarify, but she's in a whole nother state, so she may feel safe in Kentucky versus being in Georgia.
she has another child that has a child out here too in Georgia.
Yeah. Unless the state can get in touch with the victim, if they do, and they can ask for a bond modification. I'm going to just leave it at the 2,000 surety. Your history is not very good. So I'm going to leave it at the 2,000 surety bond, and no further contact from now until we can hear from her.
That
Stay-
1,000 charge, Judge?
Huh?
1,000 on each charge?
Yes, 1,000 on each. All right.
Position 4, Mr. Creighton.
This is 26 CR 0000363H with Charles Crate, charged with 1 count of battery, family violence, 1 count of simple violence. I mean, simple battery. Pre-trial.
Sorry, I'm on mute. Judge, in
Oh.
regards to Mr. Crape, 8 Cycles, Illinois, 14 Missouri. He has a hold for an FTA out of Vienna, Illinois. I'm 24. He has a simple battery family violence arrest, 12/2/25 out of South Fulton, but he was not booked in here. Let me see something real quick, Judge, because I looked at it earlier because I thought these would be on. Somebody must have put it in wrong because our pretrial report says ag assault. Yeah, it says ag assault not resulting in serious bodily injury is what the pre-file was.
You have anything different, ASG Rhodes?
No, I am showing and it's showing 2 counts of the ag assault, but not serious bodily injury as well. So I was somewhat confused by it. What I do have is that, and I don't know if pretrial has this, that the defendant went to jail on November 30th, but he got out on December 2nd for the same victim. And maybe that was the South Fulton case you were talking about earlier, but he was just in, November 30th. But I am showing 2 counts of aggravated assault, but it does says no serious bodily injury.
Mm.
Judge, what I
But
would,
you can go ahead. Anything else pretrial that's about what you have is right?
Yes, Judge,
Okay.
this is a different charge, great.
Oh,
No, because they don't have the cases linked. Oh, here it is. It's an open 25 CR 007716E,
okay.
and he has us actually got a signature bond on that case by who gave it to him? Judge Law.
All right. Okay. Thank you. Go ahead, ASG Wells.
yes, Your Honor, this was January 16th issue at 4900 Delano Road. Officers did meet with the victim in that case. In this case, Ms. Tashasha Smith, who was standing outside of her building when they actually came. And she stated that her boyfriend, who was the defendant, was still inside of the apartment. When officers did enter the apartment, they could hear him saying to her, call the police, call the police. And they identified him as Mr. Charles Crape. There was another witness inside of the residence as well, a Miss Smoot. She was seated in the living room. Ms. Smith did advise that she had been asleep all day on the couch and that Mr. Crape woke her up by yelling at her. She stated that Mr. Crape had been drinking, and she advised that when she went to her daughter's bedroom to try to avoid any further confrontation with him, he then followed her yelling and screaming through the door. She began packing a suitcase for an upcoming trip, and Mr. Craig grabbed the suitcase from her, threw those items out of the apartment. When she retrieved them, he emptied the belongings from the suitcase and assaulted her. And I think that this was all because there was some accusations of infidelity that I just don't necessarily think is appropriate to go into. Essentially, Your Honor, what I would say about Mr. Crape is that this is a battery family violence. Since he has been in the jail, he has called the victim in this case, and the victim in this case pretty much during those calls said that she did not want contact with him. The calls were set tantamount to influencing the victim, in this case, Mr. Shasta Smith. As I said before, the defendant just went to jail November 30th and got out on December 2nd for abusing the same victim. And Your Honor, that was a family violence case in December of 2025 as well. I believe pretrial gave you the number. That was 25 CR 007716E. We will be filing a motion to revoke bond on that. I've already filed that motion. That bond motion had in it a condition that he has no further contact with the same victim, Mr. Shasta Smith. And it also had in that bond order that he stay away from the same incident location, which was the 4900 Delano Road apartment in number 91 in South Fulton. And that's where this incident actually took place. So in addition to him continuing with violent tendencies, he has no regard for the court's authority, as he has violated a direct bond order that told him to have no further contact with this victim and to stay away from that incident location. And as pretrial indicated, there's a 26 PF 000515 case, 2 counts of aggravated assault, but it does say no violent, no serious bodily injury in those aggravated assaults. As such, Your Honor, the state is concerned for the safety of Mr. Shasha Smith. The violent tendencies of Mr. Crape is alarming. We are asking for a cash bond so that he is not able to go through a bonding company in the amount of $20,000 that he would have to post through the jail. We're asking that he has no further contact with Ms. to finally have no further contact with Ms. Tashasha Smith. Perhaps if he can't follow court orders, if he's in the jail, he'd be forced to. And that he stay away from the incident location of 4900 Delano Road in South Fulton, Georgia. Your Honor, we're asking that he undergoes alcohol drug evaluation and treatment. The victim in this case did state, and it looks like Ms. Smith is on the line, that alcohol was involved in this particular incident. The witness in this case stated that he threw water on her during this incident. It just seems like thing after thing after thing between these two. And Your Honor, we believe that a serious enough bond for him to get the message is in order in this case. Thank you, Judge.
All
Uh,
right.
Yes, Your Honor. Thank you. First of all, Mr. Craig does come before the court with the presumption of innocence. He does deny that there was any physical contact or that he caused any injury with the alleged victim here. He has been in Georgia for over 5 years. I'm advised that he works full-time as a supervisor with a property management company. He indicates that he and the alleged victim are ending their relationship, that he intends to have no further contact with her. Based on all of that, I would ask for a $1,500 good bond, $1,000 on the battery, and $500 on the simple battery, and nothing further from defense, Your Honor.
Okay. And this.
Your Honor, I would just reiterate to the court, my apologies, but that in addition to the previous violations of the bond order, the state does have jail calls where he's continuously contacting her. So the state does have no confidence that he won't continue.
Okay.
Well, I'm not aware of any of that, Your Honor. I don't have access to that, so I don't know about that.
To the jail calls. All right. So it's the state is recommending $2,000 surety bond. Is that right, Mr. Rhodes?
I'm sorry, Your Honor. We were asking for a $20,000 cash bond, considering the open case that he has with the same victim, the potentiality of the aggravated assault counts that are in Superior Court, and the blatant disregard of the violation of the bond order and his criminal history as recited by pretrial services. We believe that a significant bond is in order. So we're asking for $20,000 cash, Your Honor, but it is based on good reason.
Mm-hmm.
Well, the purpose of the bond, Your Honor, is to assure his appearance in court. I think the amount we asked for, $1,500, would be sufficient to do that.
Well, Your Honor, I also think that the purpose of bond is also to protect victims that can't protect themselves. And in this situation, also, the state may very well consider whether or not there are any other charges as it relates to him. We are going to file the motion to revoke his bond in his current case, where he is just blatantly violated.
Right. How much is that bond, do you know?
Yes, Your Honor.
I think it's 3 or 4. I just looked.
3,000 or 4,000?
I have it right here, Your Honor. It is a total of 4,000. Yeah, that is correct. Thank you, Madam. I believe it was Madam Pretrial, or was that Ms. Smith? But it was 4,000. 4,000 split bond, Your Honor. In that bond, he was to have level 2 supervision through pretrial services on the split bond. But it was a $4,000 split bond. If Your Honor is inclined, I would ask that Your Honor revoke that bond and to make
Your Honor, that requires notice in a separate hearing.
Mm-hmm. Yeah, I can't revoke it, but yes, you all will have to file and have that done. That was a pretrial split?
Yes, Your Honor.
Yeah, pretrial will do a revocation on that. But I will order a $10,000 cash bond. I do the number of cases and the open case are alarming with the same victim. So it'll be a $10,000 cash bond. And even Judge Law even gave him a signature bond. So
Your Honor, is that 5 on each count?
yes. And then stay away from the 4900 Delano Road. No further contact with the victim to Sasha Smith. No drugs, alcohol, weapons, or guns while on bond.
That's Ms. Smith.
Is it?
Yes, I believe so.
Okay. All right.
Hey, good luck, Mr. Craig.
Position 24, Mr. Wells. Got you.
This is 26 CR 0000370E. Cornell Wells charged with 1 count of lauder and prowling, driving, fleeing, or attempting to elude, and possession of dangerous drugs.
Judge, in regards to Mr. Wells, is this correct? 4 cycles with the marshals, felonies are owed, 19 cycles, Georgia. And those are also owed a battery and 14 and an ag assault in 09. Nothing further.
Were those convictions?
Correct.
Yes, Your Honor. Yes, Your Honor. This incident is from January 16th of this year. Around 3 a.m., Officer Heberman observed a vehicle parked in the Logan Lane Southwest parking lot. This is a public park. The address is 1620 Delow Drive Southwest. All the lights of the vehicle were off. Since this is a public park, that was a ordinance violation because he was at the park after visiting hours. When the officer approached, he turned on his lights and siren. As soon as this happened, the vehicle began driving and fled for about 0.5 kilometers. Before coming to a complete stop at 1660 Delow Drive Southwest, which was outside of the park. Officer Tatum assisted in blocking the vehicle from continue to move. The driver, Mr. Cornell Wells, was detained and arrested during a search. Mr. Wells admitted to possessing poppers, and this was found in his sweater pocket. After being Mirandized, he then stated that the substance is inhaled for a light head rush. The state's recommendation is a $2,000 surety bond, $1,000 for fleeing and eluding, $500 for the other 2 charges, no drugs, alcohol, or weapons while on bond.
Judge, let me make a correction. That was the history that I was missing for Mr. Williams. Actually, Mr. Wells has no prior arrest. So if you choose to release him, pretrial recommends a UJR jail. Nothing further.
That's what I was going to say. I did not believe he had any criminal history. I would ask for.
Did you correct that, ASG? No.
Yes, Your Honor. I was confused because I didn't see any history whatsoever. So yes, I do believe that this is correct.
No history.
Yes, Your Honor.
Okay.
And
so is that still the state's recommendation with the 2,000 on the lauder prowling, and is it 500 on the others?
Yes, 1,000 for fleeing and eluding, and then $500 for the other 2 charges. The yes, Your Honor.
Well, I only had 3. How many charges are there?
Yeah, just 3.
Okay, so 2,000 on the lauder prowling, 1,000 on the fleeing, and 500 on the dangerous drugs.
Yes, 1,000 in fleeing, 500 in the prowling, and then 500 in
Oh.
the dangerous drugs.
Oh, okay. So 2,000 total is your recommendation.
Yes, Your Honor.
Okay. And that's a surety?
Yes, Your Honor.
All right. All right, go ahead, PD Bronstein.
Thank you, Your Honor. Mr. Wells is 50 years old. He actually told me that he works as a psychiatrist at the VA. Went to San Francisco State for undergrad and med school at Albert Einstein in New York and has never been arrested before. For this case, he was in the parking lot, saw the blue lights, thought that he wanted to leave. He did stop, and said that the officer didn't tell him to get out the car, or the officer didn't get out the car and he didn't know what to do, which is why he went and then stopped again. As far as whatever inhalant or anything, those are legal. You can buy them. He was not intoxicated or under the influence. We would be asking for the signature bond jail, or a surety bond not to exceed the state's recommendation, but with no history, we'd be asking for the signature bond.
And so it was the possession of poppers? Is that what I heard?
Yes, and he bought those from the store. Those are not a Schedule anything drug.
So where's the charge for possession of dangerous drugs come from?
That is a legal question that I believe we all need to look at later. Because I don't believe that counts as dangerous drugs, but I would need to do research on that. I did give Mr. Wells names of several attorneys.
I will say, Ms. Bronstein, sorry to interrupt. I kind of did a quick search. As far as my research shows now, poppers are not illegal in Georgia. That's not definitive, but I don't believe they are.
Yeah, because that's what I thought, because he just bought them.
Right. You can just buy them in stores.
Yeah.
And I heard correct, he's a doctor?
Yes, at the VA.
All right, I'm going to allow him to have a signature bond. Are any of those restricted charges? I don't think so.
I'm sorry, Your Honor. I just looked it up and it says it's potentially is considered a dangerous drug. But
I'm
yeah, I
not
don't
going
have
to dismiss it, but I guess you all need to
I understand.
talk about it, but okay. But the fact that he has no prior history, and he works here in Georgia at the VA hospital.
Yes. As a psychiatrist.
Okay. I'm going to give him a $2,000 signature bond, 500 on loitering prowling, 1,000 on the fleeing, 500 on the possession of dangerous drugs. So that'll be a $2,000 signature bond. Since these are unrestricted through the jail, I believe he'll be back since he has a great job and ties to the area. With that signature bond, no drugs, alcohol, weapons, or unprescribed medications while on bond. He should stay away from this park. What was the name of the park?
Logan Lane.
Logan
Yes.
Lane Park. Stay away from there. And that should be it.
Thank you.
Mm-hmm.
What level is that, Judge?
That's a 2,000 signature bond through the jail. 500 on the loiter, 1,000 on the fleeing, 500 on the possession of dangerous drugs.
We go to position 15, Mr. Pan.
Okay.
Oh, and
Just a
Yeah.
heads up. Oh, I'm sorry, Mrs. Bronstein.
wait, is this the one with the offer that you chatted me about?
Yeah, I believe this is a consent bond.
Okay.
Oh, yes, yes, it's a consent bond, and I believe his wife is on in case you had any questions for her.
Okay.
And I can give you the conditions, Your Honor. Give me 1 second here. I had to do an amendment to Christopher Pierce's consent bond because I did
Okay.
victim in that case.
Okay.
Ms. Bridgewater, that is coming on Mr. Pierce, the amendment, and this is Mr. Pond. Okay, there we go.
This is 26 CR 0000373F. IO Pond or Pan, maybe. Battery, one count of battery family violence.
Yes, Your Honor. As it relates to Mr. Pond's case, we're asking for $4,000 signature bond through pretrial services level 1. That he begins the 24-week family violence intervention program that will go towards a diversion offer. That he has no further violent contact with, so he can have contact, but no further violent contact with Miss Pi. I believe it's PEI. I have Chin, CHIN. No alcohol, drugs, or weapons while out on bond. Thank you, Your Honor.
Okay.
Yes, Your Honor, I spoke with the complaining witness in this case, and she did want contact. So yes, Mr. Penn, there would be contact, just no violent contact in those classes, and the state said that that would be towards a diversion offer, which would end up getting the case dismissed as long as you complete everything, and there are no further issues.
Okay. All right. I will sign that shortly. He has a question?
Yes, George. Since like my work does require for like domestic travel and international travel, with this case, can I still like do the travels?
That's what you small. It is, and it will be via Zoom. That class is via Zoom with AACS, so you will be able to do it remotely, and it is at a reduced cost. So instead of the $45.50 that the state normally charges, it'll be at a reduced cost of $20 per session, Your Honor.
No. Okay.
So you are able to travel for work.
Yes.
You just
Yeah,
need to do the classes on Zoom.
Yeah, you're not on probation or anything yet.
Okay, so I'm able to travel internationally and domestically.
Yes, these are misdemeanor charges and you're working toward diversion, so.
Yes, and my wife is on the phone. I think her name is Jane. So you guys, yeah, if anything good, I'm good.
That's the CHIN?
JEAN.
Oh, JEAN.
Maybe with kids right now, but yeah.
Okay.
I still live with my house. Can I still live within
Yes,
my?
yes.
There is no stay away.
Yeah.
Right. Yes, you can still live in your house, as long as you don't have any violent contact with the victim here with Miss Jean Chin. Okay.
And I just contacted her to see if she wanted to say anything.
Oh, she was on. Okay. All right, that will be it.
Okay, thank you.
Thank you.
Thank you.
That's a $4,000 signature bond, Judge.
Yes. Through pretrial.
Level 1.
Yes.
She's on, she can't turn on her mic, but she's happy with the outcome.
Okay. All right.
Ms. Bridgewater, were you able to make the change to the name, or do you want me to, I could resend it with that?
On here, you have PEI Chin.
Yeah, and it's Jean, JEAN. I can send it with that.
Okay, send it with what it should be.
Thank you, ma'am. Yes,
Okay.
ma'am.
Oh, Your Honor, Mr. Jordan sent a chat about fleeing as a bail restricted charge.
Oh, let's see.
Yes, Your Honor, I just looked it up, and yes, anybody with that charge should only be eligible for release through the use of secure means.
Okay, let's see. Fleeing is bail restricted. Okay, let's see. On the previous case, is he still in the courtroom?
Yeah.
Looks like he is. Yeah, bring him back.
Would you want to do like a $1 bond, sir? Could.
What case is that, Judge?
That is going to be,
Section
I don't
24.
remember. What
20.
number? 24?
Mm-hmm.
Okay, right. And so he would have to go through pretrial.
Oh, okay. So, Mr. Wells, all that means is you need to stay in touch with the court. They're going to be checking on you to make sure that everything is going well, okay?
So he would be a level 1.
Okay.
But
Everything
it'll
else
be,
is still
yeah,
the same?
everything else is still the same.
Okay.
But we'll just have to bring him through pretrial. Oh, with number 12, we did the same thing. I think I remembered another one that was fleeing. 12, Mr. Samad Jones. Oh, that was the one in the red. He had on
Yeah.
his red street clothes and the red Dodge Charger.
Right. He did get a signature bond through the jail. Would
Yes.
that just have to change to pretrial?
Yeah.
Okay. All right. We would just ask for a pretrial bond on that, Your Honor.
Okay.
Thank you.
Thank you.
And you're saying that's position 12?
Yes.
Okay, y'all
Jones,
hold on.
Samad Jones.
Okay.
Pretrial level 1.
Yeah, sorry about that.
It's okay. Just give me a moment, you guys.
Mm-hmm.
Is that level 1? Is that pretrial level 1?
Yes. I'm sorry. Yes. Pretrial level 1.
I'm sorry, Judge, I stepped away. Were y'all waiting on me, Judge?
No, not this time. No,
Okay.
we were allowing Miss Holly to fix her orders. What happened to number 7? Fair.
Fair was a
Do you know ASG Roads?
We haven't done him yet.
It's a waiver, Judge.
he's on suicide.
Oh, he's reset for medical?
Yes.
No, they're waivers. We received.
Is
They're
that
waiting.
Mr. Fair?
Yes.
Yes, Your Honor. I can address that. He is in medical. The deputies did help me to speak with him over the phone.
Mhm.
We can waive his appearance. I did send a waiver to Mr. Jordan. I
Oh.
think based on what little I was able to talk with him about, if we could reset him to a Thursday 11 a.m. calendar, I think that's probably for the best.
Oh, okay.
And I handle that calendar.
All right. Mr. Jordan, we could do that.
What position are we talking?
Number 7.
Okay.
Yes, fair. Can we
Yes,
put him
sir.
on?
But we still need to set a bond for the case.
We still need, I
yes,
still
he-
need to give him a bond. Okay.
He does need a bond, Your Honor. Let me look.
Let me call it then.
Sure.
26 CR 000315A. and that is Damian Fair, charged with criminal trespass and willful obstruction. Pretrial, let me hear his history.
No prior arrest history.
0. Oh, okay.
Come on.
Well, we're putting him on Thursday's calendar.
It'll be the same date as the SAP calendar for that day, but at 11 o'clock.
Well, and that's on the competency calendar.
Mm-hmm.
Okay.
Which will be the 29th.
What was the state's? Did the state have a recommendation?
Yes, Your Honor, $2,000 signature bond through pretrial, level 1. Stay away from the incident location. Social service visit and a mental health evaluation and any recommended treatment, any help with housing needs.
Well,
That's
we're
it.
going to put him on the Thursday competency calendar, so that will happen. I'm just not going to give him a signature bond because he may end up out before we get that
Understood.
done. So I will make it a $2,000 surety bond so that he can have a social worker visit but be evaluated and then put on the Thursday competency calendar. So I'll make it a 2,000 surety.
One on each count.
Yes.
Judge, can we do position 16, Mr. Pierce?
Yes.
And I have a consent in that.
I'm not for sure if it was a consent, was it?
It is, Mr.
It
Pierce,
is. Oh,
everything
yeah.
I told you is incorrect. You're going to get.
Not for Fair, but for Pierce.
Oh,
No,
yeah.
yeah, for Pierce, and I'm so sorry, Mr. Pierce, everything I told you is incorrect. We're doing they clarified it, they're doing a signature bond with classes towards diversion, okay? What I looked at was wrong.
All right. So this is 26 CR 000-375J. Christopher Pierce.
That is correct, Your Honor. And let me say, I did an amendment on that as well, Ms. Bronstein. I spoke with the victim, Ms. Ross, just now. She is fine with contact. In the first one, I put no contact because we didn't have contact with her, but she has since contacted me, thanks to Ms. Smith that's on the line. And so we've amended it to no further violent contact, and we took that stay away out of there.
Thank you.
But it is the 24-week FBIP towards diversion.
Yes. And Mr. Pierce, that means that you can have contact and go back, just no violent contact, and that there's some classes, there are online classes to take. And the state said it would go towards diversion, which would mean as long as everything goes well and you do the classes and there's no further issues, it looks like this case would be dismissed.
Okay.
And Ms. Pierce, not Ms. Smith, I'm sorry.
Yes,
Pierce. It's a long day.
Yes.
So both charges are dismissed.
And then what's the amount on his bonds? I'm sorry.
I'm for 4,000.
Oh, yes, ma'am.
4,000.
Thank you, Ms. Bridgewater.
2 on each. Or 3 and 1.
No, it's 2 on each.
Okay. Thank you.
4,000 SOB level 1.
Right. Okay.
All right, that's good. All right.
Your Honor, I don't think we have addressed position 23, Cassie Garner.
I have not had any. That was the one I called the jail multiple times because it's at a different jail location.
Hello.
I
Yes,
have not
hi.
had any contact with Mr. Varner.
Hold on, Ms. Bonner. Hold on, please.
Okay.
Do not speak. So we haven't had any contact?
No, he was at South Annex, and I called South Annex multiple times and was never able to speak to anyone.
Well, well, it's a Saturday, but okay. So 23 will be reset till Monday.
Correct.
That's
Judge.
actually more of a question. Yes, Mr.
Is he not,
Jordan.
like, are they not present or?
We reset some money because there's We can't get in contact with South Annex.
Right.
I mean, would that reset go against him or who would it? Because I don't really want him to be penalized because the jail isn't.
But what else can we do?
Mr. Bartels, what are your thoughts?
Are we talking about 23, Mr. Varner?
Yes,
Yeah.
South Annex is not on the line and they never answered the phone when I tried to call him.
So how do people from South Annex appear before this calendar?
We've had them on before, like ACDC or any other. They get on, but I don't know how people reach them. I thought the jail would know.
They gave me a phone number. They just never answered me. They might answer if the
Deputy in courtroom 2, can you call South Annex?
Yeah, we still have a couple of cases to do on this calendar.
There's nobody's picking up over there. We've tried several times.
Miss Varner?
Yes, ma'am. My son just called me on the phone. He said the phone systems was down over there, and that was the reason why nobody could reach him, and that's the reason why he missed his court date. I just got off the phone with him within 5 minutes.
Well, how did he call you? Should I not ask that question?
He called me through the security system, and I just talked to him 5 minutes ago. He said the phone systems just got up. They've been down over there ever since, I guess, yesterday.
Oh, okay.
How long has he been in?
He been in there ever since the 14th.
So.
And he was supposed to went to court yesterday, and they didn't transfer him to Rice Street. And then they said he was supposed to be in today, and he still didn't get transferred because of the phone system.
Well, it sounds like it's going to be a Riverside.
It sounds like it'll be a Riverside issue. The arrest was the 14th at 5:45 p.m.
Yeah,
Yes,
that's going to be a Riverside issue.
Yeah, I'd agree that it would be Riverside. The jail had given us erroneous information about him being addressed on yesterday. It looks like there might have been some probation violation issues from other cases outside of this case, from what I saw.
Mm-hmm.
And there is no probation violation in Odyssey that's showing up.
Ms. Rothstein, is anything else holding him in jail?
No, just this. It's no bond on this case.
Stand by, Judge. Let me see if we can.
Okay.
Your Honor, we will need to readdress position 1, Mr. Barnes. It appears that Superior Court did not address him yesterday during bond hearings, and so this may actually be a misdemeanor. The state submitted a no pros for this case, but I guess we will need to address it.
When I said something about a probation violation, I thought y'all were talking about Mr. Barnes. It looks like that probation violation matters. Sorry, Ms. Bronstein.
Yes, because position 23 does. I believe this is his first cycle.
Oh, wait, is Mr. Farner 17? Sorry, we've all moved on.
He's 17
I
years
know.
old.
I'm trying to follow.
Yeah, it looks like you just turned 17.
I'm talking about 4 cases about the same time.
I'm sorry.
So now we're back to Mr. Varner.
Yeah, let's try to focus on
my apologies.
Who are we talking about now?
I think they wanted to readdress position 1.
Right.
Yes.
And then they started saying Mr. Varner was 17.
Yeah, I'm sorry. I just did that math. And realized that
Varner
he
is
just turned
17. All
He
right.
just turned
So
17.
we don't have them on the line yet, so we'll go back to position 1.
I'm sorry.
Go ahead.
That's probably why they thought that they handled it. Mr. Barnes, he's been in since December the 20th.
Yes.
Yeah, I was going to ask for a signature bond on that anyway. I mean, if the state's agreeable to that, then at least if he's out of jail, Whether it's a misdemeanor or felony can be addressed on down the line. There's
Yeah.
no warrants, there are no citations, there's no showing of probable cause.
There is the incident report, and there are warrants.
I didn't see any warrants in Odyssey or in the materials.
I'll double check, but I did see some. Additionally, he was driving and he has 11 active license suspensions.
11.
Yes, Your Honor.
Well, he's been in jail for a month. I'm advised that he was arrested and put in municipal court, Atlanta Municipal Court, on the 15th. I don't know why it's taken a month for the case to get here, but like I said, if the case is before the court for a probable cause determination, like I said, I didn't see any warrants or citations that were filed with the court.
Yes, give me one. Well, let me double check.
So let me ask this, while you all are double checking, are we withdrawing this null pros for position number 1?
Yes.
Mr. Rhodes, how would you like to handle? I know that the case for Superior Court, it still says open.
Right, that's what I'm seeing. Yeah.
See, when I pulled Barnes up on the jailing screen, I saw 2 violation of probations under cases number 23 SC 191714, and then there was a 23 PV number. I don't even see on the booking screen these charges. So I saw that they sentenced him on the probation violations, but I don't see where these charges were ever addressed. And then I went on to case manager to see if I could see these charges connected with an open case, and I do not see these charges connected with an open case.
Yeah, I'm looking at his booking screen and I'm seeing these charges, but they're listed as a felony case. It's a 25 PF case number.
Exactly.
When I type in his name, is it Victor Barnes?
Victory with a Y.
Victory.
Judge?
Victory.
Yes.
So
What do
this
you
is
have?
what happens when, so we went through the same conversation yesterday. We're having the same conversation today that we had yesterday. This case came over to us as a bind over. He was given a bond at City of Atlanta. So there's no Riverside issue. He was given a bond on the case. It came over to us as a bind over. At some point in time, we agreed to put the bind over cases on the SCA calendar instead of setting them to the SAP count. The only issue is we could not tell whether or not it should have been a felony charge or a misdemeanor charge. On the bind over document, it lists a 5,000 surety bond and it lists the charge with the code A at the end of it, meaning it was a felony driving while license suspended. If you look at the booking cards, it has the charge listed as a misdemeanor. So the question yesterday was whether or not it should be a felony or a misdemeanor, but we don't have any warrant documents or any citation to make that determination. So yesterday, the ASGs that were working the calendar decided it was a misdemeanor, and that is why they filed this case.
Judge, can I say something? We have it as a felony because for fourth or subsequent, and as I guess the ASG said, he has 7. And 1, 2, 3, 4 are in the last 4 years for driving with a suspended or revoked license.
That's where they're getting the felony from.
Yes.
And
So it should be in Superior
I
Court.
was looking at a Victor Barnes, not Victory Barnes. So
It's Victory.
I had the Barnes
with a Y. Right.
Ignore everything I said. I apologize.
We've all done that before.
So he technically doesn't need a bond hearing. If it's supposed to be a felony, then we probably just need to transfer our case to Superior Court.
Yes,
so Superior Court can pick the case up.
And he has a 5,000 surety.
And it's in the system. I see it now. That's right. It's a bind over.
Thank you, Mr. Jordan.
Mr. Jordan saves the day again. Thank you, sir.
Always.
Just to clarify, is it a felony case now?
Yes.
Okay. All right. I guess there's nothing else we can do. He has a bond set.
Right.
So for the sake of my paperwork,
Take it out.
huh?
Take out your null pros.
Right.
And it's a felony case with the 5,000 surety bond already set from municipal court. Then it was bound over so that bond would still be there.
Okay, so I'm looking at all these charges.
Yes.
I'm throwing away this null pros that I have on my paperwork. Are we gonna assign a bond amount to each charge or no? Or you
Did it-
saying it's being
did it-
transferred? Is someone gonna send me an order stating that? I just need something to.
Right. I know you need
you know.
something to close it out.
Yeah.
Yes. Do we need to do the transfer, ASG Roads? Or not? Mr. Jordan, do we have to do the transfer or no?
And Mr. Root, the felony case is still open. It just is pre-filed. Do we
Yeah, what
still?
Odyssey is showing the felony case is open and the misdemeanor is closed.
And,
Okay.
and that's why it has a PF number to it. So I think that they already have it. So I don't think we have
Not
to.
really. You would have, I'm sorry, because I
No.
do felony most of the time. They're gonna need something saying y'all transferred it because it's kind of in limbo because they haven't handled the case yet. Pre-file just means is the number they put on all cases, most cases for felony when they're first booked in. But because the warrant said misdemeanor, they wouldn't have, the felony court would not have dealt with it until it's transferred from you guys to say that it's a felony due to recidivism.
Ms.
Okay.
Milton,
Like theft by
do you have the
shoplifting.
template for felony transfer for the transfer, Doc?
Me?
Yes.
No.
If you don't have that template, I'll get that template and send it over to Ms. Bridgewater.
And there is
Okay.
a bond on all the charges.
Right.
Okay.
It's a total of 8250, 8250.
Okay.
Thank you.
Thank you.
Thank you.
So that was Mr. Barnes we were talking about. Okay.
Yes.
Yes. Victory.
Thanks.
Oh, I feel as though I have the victory now getting this.
Whew, I know, right?
Oh my gosh.
But thank you, Mr. Jordan and Mr. Bartels, everybody.
So the question at hand, what are we holding on now? What
do we have left?
We have
Mr.
Reese.
Pierce.
I
Mr. Pierce.
waived his presence and the 17-year-old in South Annex.
And we have Mr. Dorsey. He has waived his appearance. And I think there's a consent bond. That's the only case I have.
Oh, Dorsey, number 5.
Right.
Jeremy Dorsey. If that's a consent, great.
Yes, ma'am.
And that is for a $3,000 signature bond through pretrial services level 1. And that is on the theft by taking. He is to do an anti-theft course with Operation 21. He's to have no contact with Riley Christian and no alcohol, drugs, or illegal weapons while out on bond. And I do believe, Ms. Bridgewater, you have that one.
I do.
Okay. All right.
Wonderful.
Thanks, Mr. Rhodes.
All right, so we got that one. And
So then I have 2.
we're going back to, are we now on Mr. Pierce?
Oh no, we have Reese and Varner.
I mean,
I know.
I'm sorry, Pierce and Varner.
I'm showing I have a consent on Pierce.
No, we did Pierce. We haven't done Reese.
Oh, okay.
See what I'm showing on Reese.
Yeah, I don't have anything on Reese.
Yeah, he waived his presence, so we just
Oh,
have to
Reese,
go
18 is a waiver. While we have Miss Varner on there, what are we doing with that?
He's been in for almost 72
We're still
hours.
waiting on them to pick up with their
Correct.
phone problems. We're not gonna wait too long.
They're getting online soon.
Okay.
What was position 5, bond judge? What was position 5, bond?
Position 5 is
Dorsey.
hold on.
I got a
$3,000 signature bond.
Yes.
SOB, right.
3,000 SOB pretrial level 1.
Are we talking about Reese now?
That was 5. No, that was Dorsey. We were giving it to the jail. He didn't have it.
Oh, okay.
Now, I'm gonna go back to the other waiver, which I think was it 18?
Yes, Your Honor, it was 18.
Okay. Which was Reese. Now I'm up to you, Ms. Bridgewater Reese. He was a waiver. That's 26 CR 0000310Y. Anthony Reese charged 1 count of battery, family violence, 1 count of simple battery, 3rd count of terroristic threats.
Okay.
This might need to be a transfer.
What you got, pretrial?
He has a prior battery, family violence, and disorderly conduct in 12, but 52 cycles, robbery in 20 and 18, theft by shoplifting in 19, FTAs in 24, and 15. He's on probation for robbery, 2 counts, ag assault, 6 counts, 23 SC 187341, sentenced in 23 for 13 years. And then suspended sentence for meth. 6 months confinement, 6 years suspended from 3/25/25.
I'm sorry, what year was the battery family violence from?
12. Let me pull up his GCIC and it from where. Sorry. Anthony Reese. I don't think it gave me the victim because I think it's another county. Robbery. It's out of the cab 12. It's cycle 12.
Okay. And I can look up who the victim is. Thank you.
It's actually, yeah. It doesn't list the victim. It just says no violent contact. Nothing further.
Your Honor, do you want to hear a recommendation or no? Because this is a, yeah? Okay. The state's recommendation is a $4,000 surety, no further contact with victim Ms. Huff or with Michael Parrish, a social service visit, stay away from Chevron at 180 Ponce de Leon, no drugs, alcohol, or weapons while on bond.
And Your Honor, I spoke with Mr. Reese. He does have a probation hold. He's 34 years old from Atlanta. He did complete high school, works instruction. He has a lot of mental health issues. He goes to Grady and does regularly take medication. I read the warrant. He said that he does not have a child with the complaining witness. I thought the warrant said that they did. So he wanted me to let the court know that. And he said if there's no contact, he can stay elsewhere. But I told him about the probation hold and it's for a felony case. Usually people get in to see judges pretty quickly. It kind of depends on which courtroom.
Your Honor, we try to contact the victim, but we're not able to today.
Sorry about that, my camera went out. And then I couldn't hear you all for some reason. It's crazy.
Do you want me to state the state's recommendation again?
No, I heard that the 4,000 surety, right?
Yes.
On Reese. What is that breakdown? What do we have? 2, 3, 4, 2, 1, 1.
Yeah, so 4,000, 2,000 for the battery family balance, 1,000 for the single battery, I'm sorry, simple battery, and 1,000 for the terroristic threats.
Okay. And then so I will, did you have anything else to add, PD Bronstein?
So I did see a probation hold for felony case. Typically people get in to see those quickly. It depends on the judge. And he does have a litany of mental health issues, but he says that he takes medication, goes to Grady, and he was able to explain all of that to me.
Okay, well, I'll do the 4,000 surety, 2 on the battery, 1 on the simple battery, 1 on the terroristic threats. And with that surety, no further contact with the victims.
Yes, Your Honor, no further contact with the victim. I'm sorry, just one moment.
It was 2 of them.
Yes, it was Ms. Huff and Michael Parrish. A social service visit. Although I don't know if it's necessary since Attorney Bronstein mentioned that I'm sorry, he's in Grady with mental.
No, he goes, yeah.
He's
So he's
going
already, yeah.
And is he housed or is he unhoused? Does he have somewhere to live?
We had a very short conversation until he asked to waive his presence.
So if he's unhoused, that state will ask for a social service visit to help if he's unhoused. And
he said that he could stay elsewhere.
Okay, and then stay away from Chevron at 180 Ponce de Leon. No drugs, alcohol, or weapons while on bond.
What was that total bond, Judge?
4,000.
All right.
Mr. Rose, is he where he can hear me? I don't see him on here. I just received an order in position number 1, but he did not break it all down to me. And it's also an order to transfer. I need to put these bond amounts.
No, that's what it's supposed to be. Transfer orders. There is no bond. He already
Okay, so you don't want anything else to go on here as far as how it's broken down?
So we didn't issue a bond for him. The bond was issued on the bind over paperwork.
Okay.
We just needed the transfer order.
Okay, well, he just submitted an order to transfer, so we're gonna ride with that. Okay? Are we holding on anything else?
Varner, he is 20-something minutes away from being a Riverside issue. He just turned 17.
They don't have a cell phone at the South Annex?
Judge, you're on mute. It's been a long one. You're on mute. We can't hear you if you're saying something.
He called his mama on something.
Yeah, yeah.
I didn't want her to
I
say, but
know, and I was like on pins and needles here, like, ugh.
like, Mom, don't say that. But
Yeah.
No, he called her from the secured line.
Yeah, the Securus
Yeah.
phone, the phone that's available there for inmates.
Yeah, he called her properly for
Right.
so that
No.
absolutely says why on earth is a jail not here? If they're allowing him to make phone calls, they're not
Right.
allowing him to come to court.
Right. Well, if their phone system was out since yesterday, but it's supposed to be back up now, right?
Yeah. He was arrested on the 14th at 5:45 p.m. Just turned 17.
The system may have gone like that. That's why I was wondering if they have a cell phone there.
We're after 5, so we're gonna continue to wait on them, or how we gonna do this?
Well, has anybody contacted anyone at South Annex?
I thought courtroom 2 had, or the jail had, because he said they would be trying to sign on, right? Courtroom 2? Or did I make that up?
I believe we all tried to contact them.
They're in contact with them, but they're gonna put him on string.
Well, tell him to hurry up. I know you can't do that, but okay.
We're trying, Judge.
I know.
I definitely understand.
Well,
we could reconcile. You want to do that?
This is the last case. What's the name on the case?
Varner. Varner.
I think Ms. Melguizo has that one.
I'm sorry, what position is that?
23.
Oh, yes, I do have that one. 23.
You ought to worked ASG rolls out of his jacket or something.
The state's
I thought we were done.
Okay, worked him so hard. He said, I'm getting ready to get out of here.
So let me ask this here.
Uh-huh.
While we're waiting, can we go over this calendar? It's getting dark outside here, y'all. I'm the only one down here.
I know. Go ahead. Get started.
Okay. Y'all ready?
Yes, ma'am.
Once again, the reset date for the SAP calendar is January the 29th. Position number 1 is being transferred to the DA. Position number 2 is reset further notice with a total $5,000 SOB through pretrial. Position 3 is reset further notice with a total $5,000 SOB through pretrial. Position 4 is going to the SAP calendar with a $10,000 cash bond, and that's a total bond. Position number 5 is the consent bond with a $3,000 SOB through pretrial. Position 6 is reset further notice with a total $2,000 SOB through pretrial. Position 7 is going to the comp calendar for January the 29th with a total $2,000 good bond. Position 8 is going to the SAP calendar with a $2,500 good bond. Position 9, SAP calendar with a $5,000 good bond. Position 10 is a consent bond with a total $3,000 SOB through pretrial. 11 is a consent bond with a $3,000 SOB through pretrial. 12 is reset further notice with a total $3,000 SOB through pretrial. 13 is going to the SAP calendar with a total $1,000 good bond. 14 is a consent bond with a total $4,000 SOB through pretrial. 15 is a consent bond with a $4,000 SOB through pretrial. 16 is a consent bond with a total $4,000 SOB through pretrial. 17 is reset further notice with a total $3,000 SOB through pretrial. 18 is going to the SAP calendar with a total $4,000 good bond. 19 is going to the SAP calendar with a total $2,000 good bond. 20 is reset further notice with a total $2,000 SOB through pretrial. 21 going to the SAP calendar with a $1,000 good bond. 22 is going to the SAP calendar with a $3,000 good bond. We're holding on 23. 24 is reset further notice with a total $4,000 SOB through pretrial, and 25 is reset further notice with a total $1,500 SOB through pretrial.
Thank you.
I'm sorry, are there any questions, comments, or otherwise so far?
Right.
No, we good?
Thank
We're
you.
good.
Okay.
Very good. You got it.
Okay, let's do this.
Well, and also, Your Honor, once we get him here, I have not had a chance to speak to him because I was trying to call him all morning.
Well, I'm going to come off the camera for just a moment, Your Honor. I'm going to get ready to send you what I have.
Okay.
Okay.
Right. Last time, when Mr. Jordan sent it, my thing said the attachment was too large, but
Right.
I was
I
going to
try
say
to split it up.
split it up. Okay. Good. Split it
Okay.
in half. Okay.
Okay.
While we wait, can I have a breakout with his mom, who I believe is online, just so I can get some information?
Mm-hmm.
Yo, Missy,
Yes.
I just got the phone with South NS. They said they're gonna put him on in about 5 minutes.
Okay. I'm gonna hold you to him. No.
All right.
We're holding you responsible.
Your Honor, what if I waive his presence and we just go forward with testimony from his mom and his sister? Because the sister is the victim of the case.
Okay, we have the sister and the mom.
Sister and mom, yeah. And I'll submit, I'll write that up and email it to Mr. Jordan.
Okay.
Because I think I'd be fine with the court just hearing from them. I talked to sister, she wants him home and is not afraid of him. Mom says she looked and there was no gun on
All
video.
right, this is 26 CR 0000316G. And his name is Kasi Varner. Okay. Pre-trial.
No prior arrest history. If you choose to release him, pretrial recommends level 1, nothing further.
Okay,
Your Honor, do you want to hear the facts of the case?
please.
Okay, on January 14th of this year, Officer Smith responded to 874 McWilliams Road, Southeast Atlanta, Georgia, and spoke with Ms. Raven Bardner, who stated that she had a verbal argument with her brother, the defendant, Cassie Bardner. At some point during the argument, the defendant retrieved a firearm, which she described as being a black firearm, and threatened to shoot her. The defendant was inside his bedroom when the officers arrived. Sergeant Holloway issued multiple verbal commands for the defendant to exit the room, which he failed to obey. Officers then made entry into the room, and the defendant again failed to comply with the verbal commands to get on the ground, and he was subsequently taken to the ground by officers without injury. The mother, later identified as Miss Ashley Bardner, arrived on scene and provided video footage from an interior home camera. The video contained audio and showed Cassie holding a firearm while stating that he was going to pop the victim. Although there is no criminal history, these are serious charges involving a firearm. The state's recommendation is a $3,000 surety bond, $2,000 for the terroristic threats and acts, $1,000 for the willful obstruction. No further violent contact with the sister and victim, Raven Bardner. No alcohol, drugs, or weapons while on bond, and to surrender any firearms.
And then I spoke with the mom and the sister. Mom said that there was no gun on video. There wasn't a gun in the house. But I would ask that the court talk to the mom and sister. I spoke to sister. They both live with mom. He's in the 11th grade, has never been in trouble before. Sister's not afraid of him, wants him to come home. I would ask for a signature bond, no violent contact, and that he stay in school. But I would ask that the court ask mom and sister any questions.
All right. Unmute yourself, Ms. Varner.
Hello, hey ma'am. How you
Hi,
doing?
I'm good. How are you?
Good. How are you doing?
How old are you?
I'm 21.
Oh, 21. All right, raise your right hand. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down for me. So you're stating that the officers did not see a gun?
Yes, they didn't find a gun. Actually, it was just the heat of the argument. I had mistake the gun. It was really just his phone case and the flashlight. I just seen the flashlight, so that's why I thought it was a gun. And he said he was going to pop, but those were like fighting words. It was just the heat of the argument what made everything get out of context. I just needed a mediator to come and mediate the issues so we can stop arguing. It was only us two in the house, so I just needed somebody to calm down the problem. And I thought he had it, but he did not have a gun.
So you called the police?
Yes.
What kind of student is he?
He goes to Maynard Jackson.
Does he have good grades, average grades, or what?
Good grades, AB honor roll student.
Can the host let South Annex in?
I'm sorry?
The host
Somebody
let-
lit.
They're on, South Fulton is on. I think his attorney was doing a waiver, but if they're on,
If they're on, I actually just sent it, but
oh, I see it. He's on now.
Casey on here. Oh, she trying to talk to you.
based on testimony from sister, I again would ask for and his mother, I would ask for a signature bond with whatever conditions the court asks for, with the no violent contact, so that he can go home. There was no gun involved.
Your Honor, there is no way. I mean, the report says that there is video. And I would like to ask Ms. Varner if
We showed the video during. I'm sorry.
Hold on, don't cut her off. Hold on.
Yes,
I'm sorry.
Yes, Ms. Varner. So what made you think that a flashlight was a gun? A gun doesn't have a flashlight.
Yeah, some guns do have a flashlight, and I seen the reflection just on the ground. I just seen the flashlight, so I thought it was a gun, but it wasn't. It was just his phone he had under his hand in a black case. I just mistaken.
And so
it was just the heated argument that made me think it was that. But me and my brother,
and the fact that you stated, and it says in the record that he said he was gonna pop you.
Yeah, that's what he said, pop. But those are fighting words. We were just arguing. It's just a sibling argument. But he wasn't meaning like gun violence. He didn't even have a gun to pop me.
So again, my question, Ms. Varner, is how can you confuse a phone with a firearm? And how are you so familiar with firearms that you know that some firearms do have flashlights?
We own firearms, and I mean, my mama owns like 4 guns, so I know a lot about firearms. I know that it can be different accessories put on it. So I thought that he had that, but he didn't. He doesn't even own a gun.
Well, the problem I'm having now is you have firearms in the house. You and your brother have beef a little bit, and you all need to
we
cool
don't
down. And this happened.
Oh.
Hold on, don't cut me off.
Sorry.
This happened a few days ago.
Yes.
I don't know if it's cooled down. Maybe your brother is cooling down because he's been sitting in jail. But I want all the guns removed from the house.
It was my understanding that the guns were not in the house.
Okay. That's
she
not
just
no
said
problem.
they
We'll
were.
remove them.
She just said they were. Where the guns gonna be? Her mother owns 4 of them. They're in the house.
Hey, how you doing?
Hold on. I'm not speaking to you at the moment.
Oh, okay.
I'm talking. All right. So you all listen to me. And here's what I do as the judge. I sit back and I listen to people. And if I let them talk, they'll usually tell me what I want to hear. May not be what I'd like to hear, but what I need to hear. And what I'm understanding, your daughter is very familiar. I mean, she's 21, she's grown, and you all have a right to have these guns for hopefully just protection. But my concern is when they're in the house, and we're hearing cases a lot on the news with kids shooting themselves, getting a hold of parents' guns. I hope you all have a gun and have those guns properly stored and have a gun cabinet and have some safeties and this, that, the other. And, I see the defendant shaking his head. So he must be familiar with guns. And when you have them around and available, sometimes when you're arguing, people are going to threaten them because they know where to go get them.
Yeah.
And they have them in their possession. And that's what I'm afraid of. That's what's scaring me. That's what I hear. And it could be an accident. And we could be here on a totally different matter. Okay?
Okay. May I speak, Your Honor?
Now that I'm done, you can speak.
Okay, thank you so much. The firearms are locked away in the code that my mom only knows. She does not tell them to us. I don't even know the codes to the firearm. Only she knows them. So even if we probably were in trouble at the house, we would just be having to call the police because we couldn't get a gun.
Mm-hmm.
We don't know she has them like locked away in a safe, but we don't know the code to the safe. No way to open them.
So, Ms. Varner, if that's the case, what made you think that your brother was holding a gun and not just his cell phone?
Yeah, because he was just walking. It was just this heated argument. I was standing in the corner and I just took a quick glance at him and I seen a flashlight. I thought the flashlight was a gun. And I was like, oh, because we were saying the fight. We were just arguing, saying words and stuff to each other. So that's why I was thinking that he was going to do that. But I know my brother would never do it. It's
But if
just
he
that I was
doesn't,
just trying to call the police to get somebody to mediate the argument. And if he did have one, but when they came to the scene, it wasn't nothing there. So the whole time I was like, I was mistaken.
And the police have in their report, can you quote me and read in the report with Melgioso to tell me what the report says exactly?
Yes, me?
Hold on. No, Miss Varner. I'm asking
yes,
the ASG, the prosecutor, to read to me what the police report says.
absolutely. Do you want me to read the entire report or just the?
But maybe not the entire, but that part.
Okay, give me just one moment and I'll pull it up.
And who did the video come from? Them or the officers? Or is it from its body cam?
It was them. It was video from an interior home camera. The video contained audio and showed Cassie holding a firearm while stating that he was going to pop the victim.
And that's what the police report says. They got it from their internal
Yes, Your Honor.
videos. It shows him holding a gun. That's what the police report says. So you're telling me the police report is wrong?
That is what his mom told me. That she looked at the video and that there was no gun in the video.
Who looked at the video?
The mom. She said she still has the video.
Have you looked at the video, Ms. Bronstein?
I just talked to them for 2 seconds before I was able to get back in front of the court, and I had still not talked to him. Again, I was trying to call all day to speak to him to sort this all out. So no, I'm relying on what the mom and the sister say. Sister says that she is not afraid of him. He is an 11th grader, just turned 17. And I'm asking that the court take the words of the victim into consideration. They live together, they live with their mom.
I would take the words of the victim into consideration, but as you know, many victims come on and the whole story goes left and it's totally different. And she called the police because she was in fear. Most people don't call the police to be a mediator. They know that could go left. She should have called her mom or her cousin or a friend or something like that. But calling the police is pretty serious. That means you're scared. Generally. That means you're scared of something. I mean, whether it was his words that scared her or not.
I believe she has one more thing to say.
All right, Ms. Varner.
Oh man, I was not in fear of him. I actually had called my mom 3 times prior to calling the police. I did not really want to call the police. Like if my mom would have came, we would never be here. I just called her I called her first. I was not trying to call the police. I just called the police because that was my last option.
Okay. And your mom was not able to pick up.
Yeah, she was picking up the kids from school. She was gone, and I was trying to ask her where she was at because me and my brother was arguing, and it just escalated to me calling the police. I was being over dramatic. I was on the phone. Yeah, I talked to him on the phone. I was on the phone with my mama and I was on the phone with my friend. I just was trying to call people.
I'm very, very, very concerned. I'll just tell you that.
I'm sorry.
I said I'm very concerned.
Yes, I know.
So do you all go to the gun range together?
I'm sorry. Do we go to the gun range together? No. My mom doesn't take us. She just has. It's really her thing. She likes guns for protection.
Well,
for
it sounds like you do too.
Yeah, I just know about
some
them.
can
Like
have a
if
light.
it's around me, that's just something I know about.
Right. Have you been to the gun range before?
And I don't own a gun.
Has he been to the gun range before? Has he been in the back of the house shooting guns? What's your brother know about guns?
Because our mom, it's just I wouldn't know. It's just like if something was around us, we would know
But
about it.
you know some parents expose their children to guns.
Yeah. But our mom, she just let us, like, we know it's for protection for if somebody come to our house. We got private property signs.
But how can you get to the gun if it's in a gun? If it's in a gun case with a combination,
that's why
only
she's
she
home
knows.
most of the time. It's really on her. If she's not home, then we'll have to call the police. She be home most of the time. So it's like it's rare for somebody to come to our house.
Your Honor, the state did request the video evidence. We have not received it yet, so I was not able to review the video, but the state is going to continue to ask for a surety bond based on the statements and the text messages that the defendant is putting on the chat. If at the end of the day, the video shows that there is no gun, then that can be resolved later. But this is a serious charge when you are waving a gun during an argument. And it's a very serious concern. And so, Your Honor, the state is going to still ask for the surety bond.
Ms. Bronstein?
They asking for a surety bond, but he
And Mr. Varner, I don't see anything concerning about his messages, but Mr. Varner, please stop sending them. I would again ask that he be released with whatever conditions. No violent contact, stay in school, whatever the court deems appropriate.
Mm-hmm. Does your brother, does Mr. Varner have a job or anything?
Yes, I work with my mama.
Where?
She own her own cleaning business called Everything Spotless Clean. So we go clean up houses together, and sometimes I move stuff for her too.
What kind of grades do you have, Mr. Varner?
I have A's and B's. I go to Manor Jackson High School. I'm in the second grade.
Say that again. I didn't hear you.
I have A's and B's now.
Well, this is again a very serious charge.
Yeah.
And I understand that we have a video. I'm not here to go back over that. And I just honestly, and if we're wrong, we apologize. Don't think officers will put in a report there was a gun when there wasn't, especially with a video, because that could be easily told. That could be easily seen. What are you going to say?
Ma'am, I swear to God, I swear.
You stop talking.
I did not have
No,
fire.
I know. I have told the judge that.
Oh, Casey, they said you can't talk. Just stop real quick. And we showed the.
Oh, you're on mute now.
All right, I'm going to
I'm sorry, Your Honor. I'm sorry.
Go
The
ahead.
state would like to add that he reports school attendance and his grades as part of the requirements for the bond.
That he reports to what now?
Reports school attendance and grades.
Oh, okay.
And they might need a curfew as well.
Had that in my brain. Thank you. Yes, I did. I always, yeah, thank you. I'm going to make sure, and I'm going to increase the surety bond because I just want to make sure that we don't see Mr. Varner again. And I'm very, very serious about guns or the talk of guns or the use of guns. And that is concerning me. And you can always apply for a modification of the bond conditions if we find out. Of course, the state will find out if it's not true. But right now I have to go with the evidence that I have. And my inclination was to set a $10,000 surety bond because of the gun allegation. The terroristic threats, whether you had a gun or not, threaten to pop somebody or kill somebody is pretty serious. And the obstruction that, with the officers and not following those commands, those are all serious things. And, I want you to learn from it, Mr. Varner, and as we say, never to see you again, not in this setting or situation. But I will make it a $6,000 surety bond. And with that $6,000 surety bond, you are to have no further violent contact with your sister or your mother, for that matter. And I know your sister is the victim in this case. No further violent contact. Allow you to obviously go back home, but the conditions are that you will go to school every day. You will report your school attendance and grades while on bond, and he's given that to what, his attorney?
Yes, Your Honor. And if
Would it be a
We
weekly?
wouldn't represent him until he applies. So I don't
Oh,
know,
okay.
unless you want to do a split bond.
Do a
On
split
Pre-trial.
bond and report it to pretrial.
Okay, let's do that. Let's do a split bond. And what do you recommend the split be? ASG Road?
Yes, Your Honor, I would recommend that it be we could keep it at the $6,000 bond total, 4,000 surety, 2,000 signature bond through pretrial services. And if he's going to be going to school level 2, and that while he is on bond, that he report his school attendance and these good grades that he's reported to the court that he's getting, these A's and B's, that he report those to pretrial, that they be reported to pretrial services, and with the understanding that he is fully attending school, and that while on bond, he has a curfew set to where he would. Yeah. Thank you, Judge.
Judge, since he's in school, can you make it level 1?
Two times a month, it should not be that difficult. Is he working some type
It's the in-person part, Mr. Rhodes.
I'm sorry?
It's the in-person part. If he's attending school, he's in school. He would
during
have
the
to be in
day.
school to report.
Let me ask you this. He can't report after 3 o'clock? Is that
possibly, but that would be pushing it. That means
Gotta
this
get
could be setting him up
downtown.
for failure.
I 2 times a month just seems reasonable to get
It's
down.
not the number of times, it's the in-person part since he's in school.
And pretrial office closes at 5, Ms.
Yep.
Boston? Judge, I think level 2 is fine, but I'll defer to
And even with the 2 times, if I order that he can call in one time and come in one time, they wouldn't do that?
He doesn't report both times, it's just monthly. But generally, if they're in school, I would prefer not to be in person, so they're not missing school in order to report.
It's 2 times a month, Your Honor, on level 2.
2 times a month on level 2, but one of them is in person?
I believe they're
Is that
both
what I'm
in
hearing?
person, but I believe though you can order it to as one in person and one by way of phone.
I'm pretty sure I can do that pretrial if I put him on a level 2 and
Judge,
one.
that's what it is. It's one time. If it's level 2, it's once monthly in person.
Oh, okay. I think I did
And then you
misunderstood
report weekly by phone.
Got you. Okay. Then I can do level 2 since it's only one time in person. And hopefully he won't have to miss school, or it can hopefully be excused. So I'll put him on level 2. And if you can work with him on the timing, and he can be the last appointment of the day and they can make it downtown. I'd rather have him on a level 2 till we know more. His curfew is going to be from 8:30 p.m. to what time did you get the bus in the morning, Mr. Varner? Are you a car rider?
I'm a car rider. I get to school around, I think 8:30, or sometimes I get around to school. Yeah, 8:30. 8:30.
That's late.
Well,
8:30.
That's what time I start school. But I get around school like 8:26, and I'll be in the building by
Okay.
8:20.
What time do you leave in the morning?
What time I leave? I leave so first my mama, she dropped my little sister off because she in middle school. Then she come back and come get us around like 8 o'clock on the dot, and then we be there by 8:15. Then we gotta wait in the line to get inside the building. So I'll be there about like 8:26.
Okay. So 8:30 p.m. You have to be in by 8:30 p.m. and then in the morning,
Okay,
I'm sorry.
excuse me, Your Honor. I'm sorry. But another thing about it, also my school do late passes too. So if I'm late to school, they'll give me a late pass.
Okay. But we don't want you to be late.
Yeah, that's what I'm saying. I ain't aiming for it to be late.
So I'm going to say 8:30 p.m. to 7:30 a.m. in case you'd have to get picked up earlier just to make sure you get to school on time. So 8:30 p.m. you need to be in the house doing your homework. 7:30 a.m. you can begin to leave the house, or 8 o'clock, whatever time your mom picks you up. But I'm very serious about the curfew. They will call and check on you. Pretrial will, to make sure you're abiding by the curfew. And then we want you to report your school attendance and your grades to pretrial. And I'm going to put on there, Ms. Holly, if pretrial can work with him about the reporting. But if it's once a month in person, I guess it doesn't matter.
I'm sorry, Your Honor, is he in sports or something?
I know. Are you in sports or anything? Good question.
Nah, I'm not
No.
in sport.
8:30 seems late.
I was finna try out for track, but it looked like that's over with.
Mm-hmm. So we can do sometimes I do the same number, 7:30, so people kind of understand the times. So let's change it 7:30 to 7:30. So get you in the house early.
Excuse me, Your Honor, can I ask one more question, ma'am?
One last question.
Would I have a monitor?
No.
Okay.
But that doesn't mean I want you to cheat about it and be at Walmart at 8 o'clock. And when they call you, I think they have a way to tell. I'm not sure. Because they're going to do certain things to make sure you at home at 7:30. Not just with your mom and your sister and everybody. But I don't want to tell their secrets. But 7:30 to 7:30, let's make the times the same. And this is while you're on bond. It's just start some good habits. Anything else, ASG Rhodes?
No, Your Honor, that's all.
I know what else. If you have any guns in your possession, you need to surrender them to the Fulton County Marshal's Department or the Sheriff's Department. And I'm going to require your mother and your sister, if there are any guns in the home, and I understand they are, they must be at all times locked in a gun cabinet or safe. Because at first I thought about having your mother turn in her guns. And sometimes it's just a breeding ground for some issues. But I won't at this point have your mother to turn her guns in, but they are required to be locked in a gun case, safeties, and you and your sister, neither of you need to have access. The victim or the defendant. There'll be some strong language on that. Neither should have access to those guns. Anything else, Mr. Rhodes, I can think of?
I think that about covers it, Your Honor. Thank you.
All right, thank you. Any questions, PD Brunstein?
No, Your Honor.
Okay. All right, thank you. Good luck to you.
Thank you, Your Honor.
All right, you're welcome.
I think that's it.
Okay, that's it. Thank you, Deputy.
Your Honor, did you receive those other orders?
Oh, I heard the ding, so I apologize.
I'm gonna send you this one, and that should
And
be.
that'll be the rest of them. I was trying to multitask.
Okay. Well, if that's it, you guys have a good one.
You too. Thank you all.
Those of you who
Take
will
care.
be here with me on Monday, I guess I'll see you then, huh?
I will not. Have a good King holiday.
Thank you.
Have a good holiday, everybody.
Yeah.
All right, you
Take care.
too.
Okay,
All right.
bye-bye.
Bye-bye.